Good morning to one and all. I'm Rashmi. I'm CA Rashmi. I'll be the moderator for today's session. Welcome to the day 9 of Advanced GST Certification course. Today's topic is legal maxim with their applicability to GST, where usable and where not usable. We have as our speaker CA Manish Sachdeva. He qualified as a chartered accountant in 2016, currently serving in Gurgaon office of Hiregange and Associates. He has work experience of over 5 years in indirect taxes and foreign trade practices. He has undertaken multiple successful GST implementation projects across automobile, heavy engineering, and textile sectors. Manish has special proficiency in area of merchandise classification, constitutionality doctrine, exempt policies, and external aids. His articles and research papers have been published in multiple leading weeklies. Before joining Hiregange and Associates, Manish has worked in Deloitte Haskins, JBM Autos, and one leading British tabloid as columnist. On behalf of Hiregange Academy, I would like to welcome Manish Sachdeva for the session. Welcome to you, Manish.
Thank you. Thank you, Rashmi. Would you like to introduce Naveen, Advocate Shri Naveen Kumar also?
Yeah, I'll be. And today we have Naveen Kumar sir as the expert commenter for the today's sessions. It's my privilege to introduce him. Naveen sir is a lawyer practicing since the year 2001. He specialized in indirect tax litigation and consultancy. He has appeared before various tribunals, courts, and legal forums. He provides various advisory and representational service in insolvency matters. He has done BCom from Guru Nanak College, Chennai, LLB from Sri Jagadguru Renukacharya College of Law, Bangalore, ML from Annamalai University, Tamil Nadu. He is the Vice Chairman of Indirect Tax Committee of FKCCI from 2007 onwards. Recently, he has been nominated as a member of the Indirect Tax Committee of Bangalore Chamber of Industries and Commerce. He has presented papers on indirect taxes, including GST and other topics across the countries in many seminars, conferences, workshops conducted by reputed organizations and institutions, including ICI, ICSI, FKCCI, IIMB, and CBIC. He has co-authored 3 books titled Goods and Service Tax, a Premier, Compendium of Issues and Solutions in GST, and Goods and Service Tax, an abridged compendium published by Walter Clover, CCH, New Delhi. He has contributed to the booklets of GST Transition Provisions, BGM on GST, and course material for litigation management course published by ICI. He has taught business schools, business laws, constitutions, and taxation as a visiting faculty in Bharatiya Vidya Bhavan, ICI, Fiscal Policy Institute, NACEN, and National Law School of India. He has addressed officers of Central Excise, Customs, Service Tax, and Commercial Tax Department, government undertakings, and corporates on topics related to law and indirect tax. Welcome to you, sir.
Thank you.
Thank you, Deva. Thank you, Rashmi. Sorry.
Now the
Yeah. Thank you, Rashmi, for the warm introduction.
Over to you, Manish.
Yes, thank you. Good morning, everyone. Today we are supposed to discuss some important legal maxims and legal doctrines that usually come into picture while interpreting certain provisions of the law, more precisely the indirect taxes that we practice in, and often comes a situation where the bare reading of a provision does not give the exact result or as to the what the provision means. So in interpreting the same, we tend to apply some legal doctrines, some settled principles, some Latin maxims to in to arrive at a logical, at a successful, better conclusion as to what the provision means. So I have Sri Naveen Kumar with me, who's a learned advocate, and these are some of the important doctrines that we will going to study in today's session. As you can see, some of them are certain principles of settled from the constitutional doctrines, say the doctrine of misery estoppel, the doctrine of legitimate expectation. And some are the other doctrines which emanate from the common law. Plus, we have some Latin maxims. The Latin maxim, in a sense, are not legal doctrines, but they have evolved over the years by the interpretation by various countries, jurisdictional courts, and etc., so as to better provide a interpretation of a particular provision. Uh, so here's some brief background about those provisions. Naveen sir, would you like to comment on, or would you like to set a background for today's discussion?
Sure, sure. Thank you. At the outset, I thank Hireganga Academy for inviting me to this session on legal doctrines and Latin maxims. In fact, Manish is going to, he's the hero of this session, and I am just going to give my comments in between. But just to set the context, if you look at the subject for today's discussion, it is legal doctrines and Latin maxims. What is a legal doctrine? It is a rule, principle, theory, or a tenet of law which is established through past decisions. And they are principles of law and which the court accept them as such, and they are inseparable part of the legal system or material. So this is legal doctrine. So therefore, there are many doctrines which are relevant to our GST or tax purpose. So we will be focusing on those doctrines only from the point of view of the GST law per se. Then legal maxims are settled principles of law, which have been laid down by the courts and have evolved uh, mainly during the medieval period. So these maxims are in Latin, and since we adopted British jurisprudence, all these maxims are relevant to our legal system also. I think you can proceed, Manish. This is the background of legal doctrine or maxim.
Yeah, thank you, sir. So, before coming to the doctrine assess, probably I'll have some comments also. So, as you can see, these doctrines are only aids, external aids of interpretation. They're not coming out from the bare language of the legal text of the law. So, we have to apply them, whatever the principle that follows from the using the external aids. Then some of them, as I earlier mentioned, also stems from the Constitution of India itself. Like if you see the doctrine of promissory estoppel or doctrine of legitimate expectation, they are directly coming from the interpretation of Article 14. Again, they have their utility. They speaks volumes when it comes to coming to a provision, interpreting a provision. Uh, these tools for defense, these are tools for defense against the rigid language of a law. So many a times we come to interpreting a provision based on the mere language of that of the law. So probably these tools many a times give you some room or some leeway so as to modify that language or to apply some sort of a interpretation and come out with a better interpretation. Then of course these maxims are continuously developing. These the nomenclature, or I would say the application of these doctrines, have somewhat diluted or is continually diluting over the years. A court might have perceived the application of doctrine 30, 40, 50 years ago in somewhat different way, and today if we are to use this doctrine today's time, that then court might have perceived this doctrine differently. So with this background, I come to the very important doctrine, or the most prevalent doctrine that is used in the context of clubs and association to negate the taxability from any fiscal statute. So the doctrine of mutuality is based on the principle that no man can trade with himself. It says any person uh, cannot deal with himself. So merely a transaction with himself does not attract the tax liability, as in the case of a tax liability arising out of dealing between two persons. So to give an example, if I myself buy a drink from outside, the outside vendor would charge me some tax on it. Then probably I'll keep it with me for the day. On the third, fourth, fifth day, I would consume it myself. So I had the possession of that drink and I am consuming the same. It does not necessarily mean that I am dealing with myself. Because I cannot deal with myself, therefore the doctrine of mutuality emerges, and therefore this transaction has no place. In fact, that there is no transaction at all in the picture. So a leading case in the doctrine, in the concept of doctrine mutuality, arises from the Queen's Bench in the case of Graff versus Evans 1882. The English court decided the case based on the common law principle, uh, wherein a transaction between a uh, liquor club was providing to its members some drinks on consideration of some money. So a question came before the Queen's Bench whether this giving of liquor to its member would make the membership club a particular licensee, a particular, would he required a license under the respective liquor law. So the court held that since he is dealing, since the club and association are one person in itself, they are not different persons, therefore there is no transaction of sale occurring, and accordingly the club do not require a liquor license. And based on this whole judgment, the concept of mutuality arises. The transaction whereby a member of a club acquired liquor, which was the property of the club, was not the sale, but merely transfer of special property. So the concept emanates basically from the interpretation of sale, but over the years, this interpretation has crossed jurisdiction. It has crossed boundaries to be applicable on any kind of transaction, be it sale of goods, be it sale of service, or be it in the sphere of income taxes. In the context of indirect taxes, as prevalent earlier, Enfield case, a three-member bench before the Supreme Court, was a key decision. It used to hold the field. In this case, it was held by the court that so in this case the dispute was for the leviability of sales tax between selling of goods by an incorporated body. Incorporated body means it was incorporated under the provisions of a statutory act. So the Companies Act, you can argue, or the Societies Act, or any Societies Act, you can argue for that matter. So in this case, the court held that the transaction between a incorporated body and its persons is a distinct transaction. It cannot be said that the incorporated body and the person are same person. As soon as the person is an incorporated body, it gains a separate legal existence, and therefore the transaction do not hold to be uh, within the purview of doctrine of mutuality, and therefore sales tax is leviable. So the precise words of the judgment, I would like to paraphrase. Nor can it be said that society is holding its property, including refreshments prepared by it for supply to its member, as a trustee for its members. So it eroded the concept of trustee. In this case, it held that the society, when it is acting in its separate legal form, it is not a trustee of the property of the common good. A registered society is a body corporate with power to hold property and is capable of entering into contracts. It cannot be assumed that the property which it holds is property of which its members are honest. The property in law is the property of the society. So it basically said that when a society comes into the existence of a corporate form, it is not holding the property of some common people, it is holding the property of its own. So when it is holding a property of its own and then distributes it, it tantamounts to a transaction of sale, which is separate from while a transaction between the members of an unincorporated body or similar likely that. Now it basically did not apply the earlier English decisions, as was the case in the Graf versus Evans, and then there was subsequent decisions from the English courts also, on the basis that these decisions are not applicable with respect to tax laws. So the Enfield case was holding the ground for many of the years until a decision in the case of Young Men India came in before the six member bench of the Supreme Court in 1970. In this case, in fact, not only incorporated body but also unincorporated bodies and clubs were before the Supreme Court to argue their case as to whether this Enfield case is good on law or not, and also whether the doctrine of mutuality is applicable or not. So in this case, the Supreme Court held or stamped upon the principle of the doctrine of mutuality, holding that the doctrine of mutuality assumes that one person cannot deal with its members, and even if a club, even though a distinct legal entity, it is only acting as an agent for its member in the matter of supply of various preparations. So it said that there is no when a club, be it incorporated or unincorporated, when it sells to its member, it is not acting as a different vendor. It is only distributing the the asset which it had to its member. So that distribution does not tantamount to sale in its strict sense, and therefore it stand upon the authority of doctrine of mutuality. It applied the English jurisprudence as we as earlier noticed in the case of Graf versus Evans, and also it distinguished Enfield on the ground that mere absence of profit motive was not sufficient to establish society was acting as agents of member. So this judgment in essence overruled the decision of Enfield's case, at the same time not very precisely overruling it. So the Young Men case basically formed a formidable ground by various clubs and association to in the cases of income tax and sales tax and also other statute also. So it continued to hold the field. Now both of these judgments are pre 46 amendment in the constitution. As we know, after the 46th amendment constitution, article 36629A was inserted, and the clause E of such article basically said that the sale of goods by unincorporated association for a consideration or a deferred revenue would tend amount to deemed sale of goods. Now, after this 46th amendment, there's a brief history to it also of the 46th amendment, which I'll come to while discussing this famous judgment that was rendered in the year 2019 by Supreme Court in Calcutta Club. So this after 46th amendment, it was a intention, it was an indicator of the intention of the government that they're trying to catch up to the negation that was posed by the court in Young Men's Association case, Young Men Indian Association case, and it tend to apply this 46th amendment for sales tax purpose and going forward for service tax purpose also. So over the years we had some favorable and unfavorable, or I would say contradictory decisions with respect to this doctrine, application of this doctrine of mutuality in the case of sales tax statute and service tax. So this whole decisions after some controversy, there was Ranchi Club decision, there was BCCI decisions, and there were multiple other decisions. All these decisions finally came before the Honorable Supreme Court in the case of Calcutta Club Limited, where both the sales tax statute as well as service tax statute was under consideration. And the question before the court was whether the doctrine of mutuality survived even after 46th amendment or not, and whether the 46th amendment in article 36629E was has basically uh, overcome the doctrine of mutuality or not. So in this case, the court, based on various parameters, go on to held that even after the 46th Amendment, the doctrine of mutuality survived because, in essence, on basically two grounds it held so. The first was a very crucial one. Uh, it noticed is basically highlight a flaw in the 46th Amendment. The 46th Amendment, as if you could see, is only saying the words of unincorporated association. So the court said the 46th Amendment assumed that the transaction between incorporated bodies and its members was anyways taxable, and therefore Article 366/29A did not cover those entities. However, the court held that the 46th Amendment, while framing 46th Amendment in the Constitution, the framers of the law assumed that the ratio of young men or the Enfield case continue to operate in, because we had earlier read that in the Enfield case the dispute was decided in the case of incorporated bodies. So basis this, the court held that the 46th Amendment proceeded on a wrong presumption. It basically overruled that the transaction between incorporated bodies and its members was overruled, but from the ratio of Enfield case was overruled in the Young Men India's Association case. And since 46th Amendment to the Constitution did not take care of incorporated association, therefore the doctrine of mutuality anyway survives after 46th Amendment. Otherwise, also the court also held that beside be it you be calling it unincorporated association or incorporated association, both of them are not treated as a distinct person, and merely by specifying that a transaction tantamount to deemed sale of goods, you have not overcome the basic premise of the judgment, and in saying so, that you have not treated the members and association clubs as distinct person. So the court held it, and in doing so, the court also relied upon one particular paragraph, one particular section, section 224, 8 or 9, if I'm not wrong, of the Income Tax Act, wherein it said that whenever the legislature intends to incorporate, overcome the doctrine of mutuality, it uses expressive words. Like the expressive words of mutual insurance companies' profits were made taxable as a deemed transaction. So it said whenever legislature tries to cover up for something, tries to make something taxable beyond its generic taxability, it uses express words. Now because in this VAT statute in Article 369/29A, this statute had not used precisely make the clubs and its members as distinct person, the concept of mutuality has not overcome by the legislature and the state be it parliament or the state legislature, and merely providing a definition of deemed sale of goods in Article 369 366/29A did not overdo the young men associations case. Now, important concept arising from this Calcutta judgment. In fact, it had two kind of statutes in dispute. One was the sales tax and the other was service tax. In the sales tax, the court also held that, from another angle, it also held that when you say there is a sale for a consideration, the when a transaction is happening between a club and association, the transaction does not tantamount to the sale. So you are saying that you have treated a particular transaction as a deemed sale of goods, while also not considering the consideration aspect of the sale, as to whether the consideration can only be found when someone parts with his own property. In this case, when a member do not part his property, what property is his only, he's only getting it out of his special property he's getting out of by paying some money. So therefore, this consideration aspect, on this consideration aspect also, this taxability of sales tax is no longer survives on unincorporated association and incorporated association. So in the in the context of sales tax, the Supreme Court held that the levy on the unincorporated association and unincorporated association is not leviable to sales tax. While in the context of service tax, so in the context of service tax, both pre-negative list regime and after negative list regime cases were under dispute. To hold down both the cases as not proper in law, the court in the pre-negative list regime context held that since the club and association membership had an exception to it that said that registered uh, clubs and association are not covered within the purview of this taxable entry. It said that the registered association uh, includes a person registered under the service under the Societies Act as well as income tax or any other statute. So as to say, whenever a society is registered or for any time for any link for the for under any law for the timing force, it comes within the exception of that taxable entry under section 6525A subclause A, and therefore it held that service tax is not leviable before 1st July 2012. After 1st July 2012, while deciding the case after 1st July 2012, the court had a basic premise set in its mind that the concept of doctrine of mutuality is surviving, and while doing so and while setting the premise, while keeping this consideration in mind, the court went on to declare the law under service tax after 1st July 2012 also, that into after 2000 1st July 2012 also, the court has not provided that the person the club or association and the member are different person. While the judgment of the court seems to be very elaborate and discussing on all the historic aspect of this mutuality, in this in this particular 1st July 2012, after 1st July 2012 case, there is a bit of lacuna lying in there, because if you see the explanation to section 65B44, they have specifically treated the clubs and association and members as distinct person. So it is unconceivable as to the court ruling that they have not treated those person as distinct person. But nonetheless, since this decision is a Supreme Court decision and it considers all the prehistoric judgment, it is appears to be a law of land, and it would continue to apply for sales tax and service tax cases wherever the tax was already paid. It basically held that this taxes are not leviable within the frame of law. Now, coming to the having discussed on this concept briefly, we can see whether this position under the GST remains same or not, whether the status quo of this decision is applicable under GST or not. So the first very intriguing point is that this judgment with respect to service tax only covered incorporated persons from the scope of mutuality. So the first cautious exercise would be, while even deciding or advising any particular client or someone some other person, we have to be careful in mind that with respect to GST, since it bears its image from the service tax law more or less, we have to keep in mind that this judgment is not a ratio decidendi in its precise sense to say that even unincorporated associations are also not liable to pay GST. So, but again, we had the formulation by the court in the sales tax statute with respect to unincorporated person also. But again, this has to be cautiously exercised and cautiously interpreted while advising a position under GST. Now, having said that, we could examine the taxability from GST from all other angles also, because there was the ratio of the law, the ratio that formulated by the court was, you have to treat distinct person, you have to make distinct person between a member and its association. Unless you do so, the taxability no longer survives. So in the context of GST, it could be asked that merely by defining or merely providing classification schedule 2, supply of goods by any unincorporated association or body of persons to a member thereof for cash, deferred payment, or other valuable consideration, does it do away with the distinctiveness of non-distinctiveness of a club and association? it doesn't appear to be. This schedule 2 as we know it is a only classification entry. So unless those two persons are treated distinct, schedule 2 entry does not do anything, any good to the government's case. So also, whether defining association as in the definition of person in section 284, does it also do away with the non-distinctiveness of a person association and its members? Probably not so, because the definition of person is only elaborating what kind of a person it would be treating for the purpose of a taxable person. It is again not defining or not explicitly saying that the club and its member are distinct from each other. There is one intriguing aspect, although, when it comes to defining the definition of business. In section 217 clause E, it says that the business, the sale and supply of goods and services by the clubs and association to the members would tantamount to business. So probably this defining of business in subclause E is a only ground available to the government to say that by this clause we have made a particular transaction as a business transaction. So therefore it is implicitly coming out from this that this transaction between the club, in fact the person, the club and its association are distinct person. While the state and the parliament could say so, however, when we read the judgment of Cricket Club India in its Calcutta Club India Limited in its entire broad sense, it does not appear to be that merely also providing something called as business. They have treated two persons as distinct persons. So probably this judgment would have ramifications under GST, large scale ramifications under GST, because the whole concept of the doctrine and mutuality, as the way interpreted in Young Men, as the way interpreted in Calcutta Club Limited, has a very large scope for the government to rectify in the legislation. And probably seeing this, how the trend is, the government may end up doing some retrospective amendment also. So probably we could, while going forward, what we could do is to whenever we see an RW or any association like that, we have to cautiously see how much is the ramifications coming out of GST if a RWA starts paying GST on its collections from the members. If the position is more or less revenue neutral, probably a stand should be taken that going in for the GST taxability of output supply rather than taking the shelter to this judgment. uh, Besides, the judgment could also be seen from the interplay of section 25(4), which says that a branch of a person or a registered person having registration in two different states would be treated as distinct person. So when I say that when the law says that I am specifically treating one particular entity as two distinct person only in this particular case, so and not providing some any other case, can then government argue that okay, even in fact by providing definitions in the business, by providing entering schedule 2, by providing the definition person in section 284, can the government say that this implied in these definitions that I have deemed those person together different person? Probably not, because if that was the case, then why section 25 was there, section 25(4) was there at all? So with this, we can have some expressive thoughts from Shri Naveen Kumar as to how to take this decision going forward in the GST, and how the view of the court is relevant, or does it hold propriety in its entirety. Over to Naveen, sir.
Yeah, thank you, Manish, for starting the discussion with a very controversial issue relating to mutuality. In fact, as we go on with the slides, we should also ask ourselves the question as to why we should look at the legal doctrines and maxims.
So your
As I
voice is
told you at the
breaking in
beginning,
between.
Hello.
Yes, sir, it's clear now.
We should also understand or ask this question as to why we require to look at the maxims um, in our study of GST. I told you in the beginning that these are all settled principles, and the courts need not again reinvent the wheel. It is readily accepted by the courts whenever you refer to some doctrine or a legal principle or a legal maxim. And I always believe that law is not a destination, it is a journey. And in a journey, you cannot stay at one place, you have to keep moving. And that is how law also evolves. That is the process. And we use while the courts use some tools to understand the law or interpret the law, they use the interpretative principles for resolving the disputes. And in that context, these doctrines and legal maxims would come handy. As regards the mutuality principle, which Manish was elaborately discussing, I am reminded of one old judgment of Supreme Court in 1953. It is Sir Kikabai Premchand's case, 24 ITR 506. The Supreme Court, probably for the first time, looked at the aspect that one cannot do business with oneself. In fact, I remember witnessing a matter which was argued by a senior counsel before the Sestat Bangalore, where he was engaged by some club to argue a case that was about probably 10 years back. And he put it across in this manner. He said, what is mutuality? Because the bench also had the same doubt. So he did not go to any doctrine or any other case laws. He just said, assume for a moment 10 friends in an office decide to go for a picnic and they pool some funds. They contribute 1,000 each and they go for a picnic and come back. They find that there is a residue of 500 rupees. Does it become taxable? That is principle of mutuality. That is how he explained the principle of mutuality in the court. So that is exactly what it is. They act for each other, and there is no question of saying one person has rendered service to another. I also remember arguing one case before the Karnataka High Court, probably the first case in South India, Century Club, where we tried to use some of the judgments of the Supreme Court in the context of income tax law, because this principle of mutuality has evolved in income tax also. And there, the Karnataka High Court did not accept the argument on mutuality. The first day I argued the matter, the next day my senior appeared, and the judges were against that, adopting that principle. Now, as far as the issue in the sales tax was concerned, after the YMIA decision came, they came up with a constitutional amendment in 1982, the 46th Amendment, which Manish was also referring. Under Article 366, 29(8), there was a definition brought in of deemed sale. One of this was to overcome the mutuality principle. Now, coming to this Calcutta Club, if you read the Calcutta Club judgment and finally pose a question, what about unincorporated association? You may not get a clear answer at all. But at the same time, we should also understand that according to this is my personal view, in the context of sales tax, they try to overcome the mutuality principle by a constitution amendment. So unless they also bring in a deemed service definition in the constitution, in my view, they would not be able to overcome the mutuality principle completely. And therefore, my personal view, with great respect, is that the Calcutta judgment might not have fully covered the issue relating to mutuality principle or unincorporated association. Therefore, in future, when some dispute crops up in GST law, the issues may again go back. As I told you, it is only a journey and not a destination. Therefore, law keeps on evolving in that way. But as far as the practical thing is concerned, whether you can advise your clients or if yourself are a representative of a club, can you stop paying tax? That could lead to risk, because this club issue, in the context of VAT or sales tax, it started long back. And you see in Calcutta judgment, Calcutta club case being decided in 2020. In the context of service tax also, it started more than 15 years back, and the judgment comes now. Even now, there is a lack of clarity. In fact, I am handling one matter before Supreme Court, where the department is raising this exact question, that Calcutta club case does not address the issue relating to unincorporated association. They say that unincorporated association anyway taxable. So therefore, the amount of the litigation would depend on what is the stakes involved in a particular matter. Is it worth fighting? All these aspects should be decided. Otherwise, they are in for a long battle. Over to Manish.
So we are losing your voice in between. So is there any internet issue or what?
I don't know. You lost it completely, or was it audible?
It was audible to a large extent, but the last few words we actually went haywire.
Okay.
Sir,
Maybe
but
I'll
it was
repeat that
audible,
once.
sir.
Oh, I see. Okay. Then probably, Manish, your connection, there is some problem.
Yeah. Okay.
Okay.
So I'll continue, and probably we'll come back to your the left comments once this session comes to a good conclusion. Thank you, sir.
Yeah.
Yeah, thank you, sir. So next doctrine is about the delegation aspect of a delegating. So in the constitutional, it is recognized through various articles that there are three branches of administration. One is the legislature, who frames the law, then the executive, who takes the executive orders and actions, who implements the law, and then there is a judiciary, who takes hold of the interpretational issues, who decides how the law should be read and what the law is. In Keswananda Bharti versus state of Kerala, the constitutional bench had laid down the concept of separation of powers in our constitutional with respect to our constitution. It says the constitution of India does not lay down the principle of separation of power in its all rigidity, as in the case of USA Constitution, but the functions of different organs of governments have been clearly demarcated and earmarked so that one organ does not usurp the function of another. So the concept arising from this separation of power is that no, the one organ cannot exercise the functions and responsibility of the another organ. So when it comes to the executive, be it the central government or the officers of working under the president or the government, they cannot frame a law. They cannot come to a making a law which is not implemented, which is not legislated by the parliament or the state legislature. They can only implement a law. And wherever any executive action or any framing of rules by the central government is in the nature of framing a new law altogether, which only a state legislature or a parliament is authorized to, shall be invalid in law. So the concept of delegated legislation comes from this separation of power. It says the power to delegate is constituent element of legislature power as a whole. However, the delegating must exercise its jurisdiction within the four corners of its delegation. So it is settled law that a legislature can delegate, because it is accepted that unless a delegator and the works of executive exercise are delegated to the government, the legislature cannot do so, cannot go on and frame law with respect to every other aspect of a particular subject. So what the legislature does is it defines a law, it gives an indication as to the policy, it gives some guidelines, and then it leaves up it to the delegate to frame laws, to make rules, to implement that subject. And in the course of doing so, it could also enact some kind of a law which does not usurp the whole the basic law of the legislature, but at the same time it can frame laws to implement the law. So if a delegate exercise powers usurping its authority, unless subsequently ratified by the legislature, such actions are held invalid. It has been held countlessly and continuously and frequently by the court that a delegate, be it central government or any other rule making authority, in the case of, you may call it as a central board of indirect taxes or the direct taxes, or for that matter any other department, uh, it cannot exercise its delegative power to make law, which is the exclusive power of a legislature. So another concept of this separation powers is that the legislature can delegate, but it cannot delegate in excessive sense. So that in the first concept, we heard that the delegating can act within the four corners of its delegation. In the first concept, the delegate was not acting within the delegation power granted by the legislature. In this excessive delegation concept, although the delegate is acting within the power that has been granted by the law, but at the same time the court also sees whether the delegation that has been given by the law to the implementing body, is it so enlarged, or is it so important that the legislature should itself had confided that power to itself, and the delegation of it to a delegate absolutely would make the laws made by the delegated has the potential to make those law by the delegate as arbitrary provision, such that the court tries to enforce a morality into the powers exercised by different organs. It says that when the legislature it says this legislature cannot delegate unrestrained, uncanalized, and unqualified legislative power on an unadministrative body. Legislate it must by laying down policy and principle, and delegate it may to fill in detail and carry out policy. If the guidance is there, wherever it may found the delegation is valid, and if there is no guiding principle following from the legislature, and the power is so uncanalized and unrestrained and unqualified, then the delegation power would tantamount to would fall wise to the concept of excessive delegation and shall be held invalid. So we have to conclude, we have two kind of uh, concept wherein the delegation power could be held invalid by a court. One is where the delegate has exceeded its jurisdiction, and the other is where the delegation by the law itself is excessively delegated, and it has the potential to cause arbitrary exercise by the delegate. Now, in the context of it, probably we could see whether the Rule 36(4), which has been enacted by the central government to restrict the ITC on a threshold basis, whether this exercise whether by formulating this law, whether the central government has exercised its jurisdiction, because this kind of unrestrained power is not provided anywhere specifically in the law. Section 16 or 17 only provides that the ITC is available to subject to certain conditions and procedures. Now, whether this 10% is a condition on appealing ITC, or is it basically putting a restriction? So conditions, it may be from the point of view of controlling how an ITC can be availed by a registered person. But does the government has enough or massive powers to say that this power also includes putting a restraint on the amount of ITC then that can be availed? Probably it appears that this power of restricting credit on some threshold is not provided by the legislature, and therefore exercise of this power by central government may tantamount to usurping its jurisdiction and hence invalid. Similarly, if we see section 177 of the CGST Act, which is creation of an authority called Anti-Profiteering Authority, National Anti-Profiteering Authority, and section 171(3) gives an excessive enormous power to the authority to make rules and regulation as per their own whims. So if we see the whole concept of anti-profiteering in terms of international guidelines and all those, the legislature had provided some kind of guidelines to the implementing authority to make sure that this power is not arbitrarily exercised. But when we see section 171, there is no guidance flowing from this 171 unless interpreted otherwise by the court, that says the implementing authority, which is the government or the NAPA, has any kind of restraint on its power. So if we see the orders of that are coming from the NAPA, they are also in some sort of the sense that one is presenting different kind of ruling and the other is presenting different kind of rulings. In kind of samely situated persons, they are deciding differently. So these orders that have been exercised by the NAPA are so unrestrained and unqualified. In fact, whenever a question is posed to them as to their jurisdiction, they go on ahead and come to a conclusion that it is within their powers to decide their jurisdiction. So it appears that the power that is delegated to NAPA is so excessively delegated that it is leading to arbitrary exercise by them, and therefore this section 171 may fall wise to the wise of excessive delegation. Naveen sir, if you can have your comments on this.
Yeah, sure. Thank you. See, if you look at delegated legislation, what are the examples we can look at? It may be a rule, it may be notification, it may be some order, etc. That also attains the status of law. So I have to give a simple example. Take a traffic signal or a one-way which is notified by the police department. But for the delegated legislation, the assembly has to sit and decide which road we have to keep one way, which signal we have to keep, what is the duration, etc. So that is the purpose of delegated legislation. Now there are two
So
things
we're
here.
losing your voice in between. There's breakage.
Rashmi, are you able to hear me?
Rashmi,
Yes,
if you
sir,
could
it is
check
clear,
what
sir.
might be the problem.
No, it is audible, Manish. I think it is your
Okay,
network issue.
okay, then it's fine. Okay,
Yeah.
Okay.
okay.
The excess, there is a difference between excessive delegation and ultra vires. Excessive delegation is the legislature has given some powers which is actually to be exercised by them. That NAPA example, which that National Anti-Profiteering Authority example, which Manish gave, is a classic example for that. In fact, the jurisdiction and the provisions have been challenged before the Delhi High Court in pyramid case and subsequent judgments. One more thing is ultra vires. When a delegation is proper, but the delegatee is trying to exercise some powers which is not actually delegated to them, that is called ultra vires. And to give one example of excessive delegation, you would find it interesting to read the Delhi High Court judgment in Indian Association of Tour Operators, where the Delhi High Court had an opportunity to examine this whether you can tax some services which are happening outside India. So there the provisions of Rule 6A of the service tax rules which dealt with the export of services, was challenged as excessive, and the court upheld that contention. In fact, what they have done in the context of GST is all these provisions which were there as a part of the place of provision, place of supply rules, have become a part of the Act itself under the IGST law. So now it would be interesting to see whether you can still use that judgment of the Delhi High Court. In fact, we also discussed it last time in our session, where we were saying that is there an extraterritorial operation? You remember we discussed that in the last session. So that
Right,
aspect
sir.
also should be brought in this context. Over to
Right.
Manish.
Yeah, thank you, sir. Uh, this concept, or I would say this, the way of interpretation of a taxation statute as to how to, whether to read it strictly, whether to read it liberally, it is a very uh, universal concept. And in the case of Commissioner of Customs versus Dilip Kumar and Company, it was a customs case, and it was the court very beautifully, in fact, summarize all the judgments of past and cleared a very mindset of to be precise as to how the interpretation of a statute should be undertaken, how an exemption entry should be interpreted. So I highlighted some key pointers from that judgment. The court basically summarized earlier decisions and said that strict and liberal interpretation should be applied at different stages of interpretation. So it said that there are two stages of interpretation of a particular statute or a taxation entry, whatever the case may be. So at the first hand, you should evaluate applicability of an ambiguity. In case you see an apparent ambiguity in a provision of law, it should be applied very strictly. When I say strictly, it means that you should not be uh, adding words to the interpretation. You should not be overarching as to the intention of the law, but you should be seeing as to the bare reading of a law. You should be seeing what it actually means rather than what it might intend to read. So probably at the first stage, you should clear that ambiguity and then proceed forward. If a particular, let's say, taxation entry say that there's it uses the words in relation to, so you can interpret this word in relation to in a broad sense. But however, when it says in, or it says to, or it says any other word like that are restrictive in nature, then you should be reading those entry in a strict way, in a very rigid way as to what this entry might be saying. So now, having done so, the court says once this ambiguity is resolved, then you should be construing the residuary and procedural process liberally. It says whenever a person is found to be within the applicability of an exemption notification and he is materially qualified for that exemption, then you should apply the procedural and other residuary clauses of this taxation or taxation entry or a statute. You should be applying those, you should be construing those provisions liberally. With liberally, it means that you should not be forfeiting the very exemption on the basis of some procedural lapse by the claimant. It says if the two views are possible within this charging section, it should be construed in the favor of assessing. So this interpretation basically goes in a two ways. Whenever there is an exception, it goes into the favor of the claimant who is claiming to claim, who's claiming that exception. So when I see that there is a charging section, the ambiguity is with respect to a charging section, then the revenue must be saying so that it has tried to define a particular class of person or a particular class of subject. Then you should be construing, if there is an ambiguity with respect to charging section, you should be reading it rigidly, saying so that it is only covering those particular class of persons and not within its expansive manner to try to include person which can be some by way or the other, adding addition or deletion of words could be come under that charging section. In the same way, when it comes to an exemption, now when it comes to an exemption, the charge of levy has already been proven. It comes to exemption, we should be reading that exemption is limited to a particular class or to a particular subject. Again, when interpreting a particular subject and class, we should be reading it strictly. Saying so, it would mean that when there is an ambiguity with respect to an exemption notification, the court held that it should be read in favor of assessee. So it basically overruled some other judgment, like there was in the case of Sun Pharma and others. It says that those decision does not present it clearly what our interpretation of an exemption notification should be. So it basically clear a lot of mindsets. It said the strict interpretation and literal interpretation at times overlap. However, strict interpretation does not necessarily refer to literal interpretation. So the court basically distinguished what strict interpretation and a literal interpretation is. Now, the literal interpretation, as we know it, is reading a law as it is. It is not addition, deletion, or of supplying any sort of words in that language. However, the court said that literal interpretation is somewhat different from strict interpretation. At times, those interpretation may overlap, but generally, the strict interpretation not necessarily be read as literal interpretation. At times, when the interpretation of the literal interpretation is indeed giving some absurd result, the court would always have the authority to apply the interpretation harmoniously, to read the provision harmoniously in order to make it strict on its paper. This decision also endorses the view taken in Harichand Sri Gopal case as to the difference between a substantial compliance and a procedural compliance. Now, the substantial compliance means when a person is falling within the substantial framework of an exemption notification, or for that matter any other provision of the law, then the benefits accruing or the limitations accruing to that substantial provision should be applicable on him. And when it comes to satisfaction of the substantial compliances, the procedural differences that the person may commit, they should not be taken away the whole benefit granted to the person. Now, if you could see, if we could all remember, there was a judgment in the case of Mrs. Maxim Tubes, wherein the Gujarat High Court had held that the pre-import condition with respect to advance authorization as bad in law. At one place, the court has also said that when you are trying to frame a law, you should be reading it in its broad sense, in its strict sense, such that the government is trying to give you some benefit, and by giving some by providing a certain conditions, certain procedural aspect, that pre-import condition. Now, this pre-imported condition, the court interpreted that provision as it would not be possible for a man of rational principle uh, to see through whether he is complying with the pre-import condition, whether he is able to comply with the pre-import condition or not, because these operations of a manufacturer are manufacturing operations are continuous operations, and he cannot identify which lot he had imported, and with respect to which lot he's been able to satisfy that pre-import condition. So the court basically held that these are procedural compliances, and this should not be taken away as overarching the whole substantial benefit that the statute is conferring upon. Once a person satisfies the broad provision, the substantial compliances of a law, then he should be given advantage to those provisions. Over to Naveen, sir. Naveen, sir.
Yeah, thank you, Manish. See, if you look at whether to interpret some provisions strictly or literally, the decision also depends on what type of provision we are interpreting or what type of notification it is. If you look at, for example, if you are interpreting a penal provision, then strict construction has to be applied. If you are interpreting a charging section, you have to construe it strictly, and the burden is always on the department to show that something is taxable. Coming to this
Rashmi, whether Naveen sir is audible?
No, Manish, I think he is not. He is not unmuted.
Hello,
Hello.
Uh,
Uh,
yes, sir.
Sir,
are you
it was mute.
okay? See, as far as strict construction or liberal construction is concerned, you should look at what type of provision you are interpreting to apply strict or liberal construction. For example, when I look at a penal statute,
Uh, Rashmi, if you could
Hello.
check in the background what problem might be.
I think it
Um,
is sir's network issue. Naveen, sir?
okay. So probably we could continue and come back to Naveen sir. If Rashmi, if you could check in the offline mode as to availability of Naveen sir.
Yeah.
Yeah. So we continue with the principles of promissory estoppel. And the estoppel basically means a conclusive admission which cannot be denied. So the principle, although named estoppel, the doctrine is rather based on the principle of equity to mitigate the rigor of rigid law. It aims at relieving the victim of arbitrary assume of abuse of discretion and pin down public authorities to act honestly and in good faith. So to explain this, this doctrine basically serves the equality clause under the Article 14 of the Constitution. So Article 14 says that there should be equality and equal protection of law for every person. Now, when I say equality, it aims to honor the equal protection or equal uh, uh, exercise of responsibilities by a public authority. Whenever public authority exercises action, it should be equitable. Unless it is equitable, it would lead to discrimination and discretionary powers and would lead to arbitrary exercise of powers with them. So when I say that a public authority has come into agreement with a person that he would do so and this thing and that thing based on the comfort given by and based on those comfort and assurance given by public authority, the person to whom the such commitments have made arranges a affair, changes his position and puts him in a derogatory form because he was expecting the benefits from the public authority. He had altered his position. Now if the public authority is allowed to go back on his promises, it will lead basically fraud on himself. So the court have interpreted this equitable principle in the form of by the name of promissory estoppel, which says that a public authority must conform to the promise that it had made, and it is stopped from backing from its promises because it would ensure equality, it would ensure equity of the law. Now the very key principle of this doctrine is that it should ensure equity or equality. If in case the exercise or backing of a promise by the public authority also ensures equity, then this doctrine of promissory estoppel would not be applicable to for taking action against the state, because at all the basic objective behind this doctrine is to achieve equity. Now, if the equity is being achieved by backing out the promises by the government, then it would be applicable as is. It would be equitable for the state to go back on their promises. Now, this concept is a very broad concept and is usually applicable in the taxation statute in terms of in the in the context of various incentives that are promised by the state or state legislature or the parliament. We have a rich history of the granting of state incentive policies by the state government, various state governments. and the governments usually allow those benefits based on the incentives investment made by the respective investee. The sales tax exemptions, the exemption from excise duty in the northeastern region, and the state of Jammu Kashmir and Himachal Pradesh, all these were based on incentive in investment made by the respective investors. Now, if based on once those investors had qualified for those exemptions or the benefits arising of those state incentive policies, they should be continued without altering their position, without making them suffer on account of any change in stance of the government. So government could any day come up with their change of the stance and say that for earlier 5 years ago it was permissible for me to give you this benefit, but now my position has changed this much that I my funds do not allow my funds do not allow me to continue those benefits. These type of a cases, the court says that state cannot back up on its promises because it would be an act on the it would be an act of fraud by the government. So promissory estoppel ensures equity by stopping public authority from going back on its promises. The important aspect about promissory estoppel is that it is applicable only with respect to executive actions and delegated legislation. It is not applicable with respect to statutory provisions of the law. So if a particular provision is framed within the statute itself, it says that a particular, say a state incentive policy was being continued for 10-15 years, and coming tomorrow in the GST law they put a specific prohibition as to not continuation or not provision. I'm using the word prohibition. So the state legislature puts a word that incentive policies are strictly prohibited from the ambit of GST law. In those cases, it would be said that promissory estoppel, being against the law, would not come to the rescue uh, of a claimant. So it can be applied with respect to executive orders, as we have seen in the case of Maharashtra state incentive policy. The Bombay High Court had held that the executive action by a commissionerate in denying the benefit of GST based on the incentive policy was against the principle of promissory estoppel, and it directed the central government, the public authority, to make laws, to frame laws, to ensure that the claimant receives the benefit of the incentive policy. In a recent judgment of uh, the Supreme Court, it is basically held that promissory estoppel is not applicable if the government intends to rectify those law with respect to some unscrupulous persons who are trying to defeat the very objective of the scheme. So promissory estoppel also, since it is the very base of this principle is equity. Now equity base basically ensures that same person should be granted the benefit which they're entitled to. If any unscrupulous person, he basically very defeats the object of equality, he does not comes out with a clean hands, then this doctrine cannot be resorted to by him at all. At the very threshold, this doctrine would not be applicable to him. uh, with respect to GST, we could probably see for whether those incentives that were earlier available by the under the central regime, uh, central government regime, which was the excise duty exemption in the northern eastern area in the state of Himachal Pradesh and Jammu Kashmir. And since the government has some sort of rectified as to how those benefits should be claimed under GST, probably a ground of promissory estoppel could be taken against them if a person feels substantially injustice, his incentive has reduced on account of change of mechanism by the government. He can come to the he can come out with a petition before the court that because of the implementation of GST, his benefit that were promised to him have been substantially reduced, and he can plead this argument of promissory estoppel. Although the Delhi High Court, in the case of Hero Motor Corp, has denuded, has declined to interfere with this. reduction in quantification of benefits, but it 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 ignores certain other previous judicial precedents. So we might have to see as to whether this the order of the Delhi High Court would hold good before the Supreme Court or not. Now there was another decision with respect to licenses under the erstwhile the licenses of advanced authorization and EPCG issued before 1st July 2017. So the government had promised the importers that customs duty at the time of import would not be leviable, and just because the GST came in, they have to pay IGST on their imports. It would not be equitable for them to go back on their promises. In the case of JTL Infra Limited, the court, the Delhi High Court had, although had accorded the benefits of those advance authorization EPCG, but it had not specifically used this argument of promissory estoppel. In our view, basically this promissory estoppel is not limited to state incentive policies. It should be applicable to all kind of promises that government makes, be it the advance authorization or EPCG cases, or be it the MEIS and SEIS that were issued before 1st July 2017. So probably if a case could be brought before the court, we might have to see how the challenge could be taken up. Of course, this is just a broad overview of what could be done. It is not uh, entirely saying that I'm not entirely saying that this principle would be applicable in all cases, because at the end of the day, this doctrine is at the discretion of a court. The court would interfere only. It is usually seen that only when a petitioner brought such substantial evidence before the court that he is being unjustified, his benefits are unjustifiedly taken from him, then only the court takes recourse to this promissory estoppel law. I'll read a legitimate expectation doctrine along with, and then probably we could have some comments with respect to both the doctrines from Naveen sir. So this doctrine of legitimate expectation also stems from Article 14, in the sense that it also aims to ensure equality and equity. The principle arises out of a reasonable expectation of being treated in a way by an administrative authority, even though the person who has such an expectation has no right in law to receive the benefits first. The expectation may arise from an express promise or consistent course of practice or procedure which the person claiming the benefit may reasonably expect to continue. Now, this doctrine has the assumption that when a person is being treated, has an expectation of being treated in a certain way. So when I say that I am a farmer, I have a legitimate expectation to be treated exempt from my output tax liabilities. And I also have a legitimate expectation that my agricultural income would not be taxed under the Income Tax Act. So this forms my legitimate expectation. This legitimate expectation as a farmer, I'm seeing this because this has been the trend of the government for so many years. Now, tomorrow, government, if at all, out of a sudden charges tax on my output produces, or I am being made subject to income tax on my agriculture income, it would hurt my legitimate expectation. Now, this legitimate expectation may come from a doctrine, may come from a expressive document that I had taken some document from an executive body or some other authority that I would be granted this much of the benefit, although that benefit might not have been legal in law per se. And as I said, there was the other aspect that I was in a continuous trend. It was a continuous practice of the government to exempt, though, to not to tax agricultural incomes and agricultural produce. So this the person claiming legitimate expectation has to either show that he was expected that a certain way was being that he was being liable to be treated in a certain way by a statute, even though that way was not recognized by the law. Now, based on these doctrine, the court may apply that, okay, there is an equality of him being treated in a certain way, and therefore the state government is required to subscribe to those expectations and do not proceed against that claimant. Now, a classic case would be the newspaper, the taxabilities of newspaper. there is a sense of freedom of press in India, and it ensures that the newspapers and the uh, dailies that we read in our homes and offices, there is a common assumption or a common sense that these should not be made liable to output tax, because if these things would be made to liable to output tax in the form of VAT or GST, it would kill a perception of a person to read about the law, because read about the daily affairs. Once it is curtailed, his daily reading of a daily affairs is curtailed, it would inscribe upon the, it would hurt the common sense of a freedom of a person uh, to read or anything like that. So therefore, those persons have a legitimate expectation that newspaper in its the output taxes on newspaper should not be made taxable. So in those cases, those persons manufacturing and distributing newspapers could come to a court just in case the government tries to tax those newspapers and say that this doctrine is applicable, and taxes, if any, should not be made applicable on them. If you see, there is a change in after the 101st Constitutional Amendment Act. This entry 92A or 92B was omitted and amended. So earlier there was restriction on the newspaper. So the only central government was authorized to make laws with respect to newspaper, and there was no tax at all ever on the newspaper. But now, having deleted that newspaper from entry 92A, that newspaper has automatically come within the fold of GST. So probably now the government might have had the legal power to make a tax or to charge tax on the newspaper. However, a person manufacturing newspaper or distributing the same could always come to the uh, legal forum and argue that I have a legitimate expectation and therefore tax should not be leviable on these kind of newspaper. There's one last thing about LE I want to highlight is LE has two aspects. One is the procedural aspect, which relates to expectation of hearing before a decision is made, and the other, which we just discussed, is a substantive aspect, which relates to expectation of obtaining a favorable decision. So, the Union of India versus Lieutenant Colonel of Colonel P.K. Chaudhary, 2016 for SEC is a landmark decision which highlights all the principles emanating from legitimate expectation. Over to Naveen sir to give his comments on promissory estoppel as well as legitimate expectation.
Yeah, thank
Naveen
you.
sir.
Yeah, thank you, Manish. Few quick points. Uh, First one will be on strict interpretation because I think you missed my voice. I'm sorry about it. Dilip
Yes, sir.
Kumar's case is something which is used by the department left, right, and center without application of mind. They are probably under the mistaken belief that two views means assessee's view and department's view. It is not so. It is not a case where the Supreme Court did not say that whenever department has a different view, then it should be decided in their favor. If you look at the Dilip Kumar's case, what they say is if two views are possible, that is the person judging it, he has two views. Therefore, he would decide in favor of the assessee. That is how you should construe Dilip Kumar's case and not in the way in which department is trying to apply it in all cases. Because there's always a different view by the department. As far as promissory estoppel is concerned, the courts also look at one more important aspect, that is greater public interest, which should pave way for this doctrine of promissory estoppel. And this was applied, this principle of looking at greater public interest was applied in Unicorn Industries case, which is reported in 289 ELT 117. So if you want to read further on that, you can have a look at it. Coming to legitimate expectation, the doctrine is not merely expectation, it should be legitimate expectation. Therefore, it should not be based on flights of fancy or mere imagination or dream that they expect something from the government. So, this is how the courts have also looked at it. Over to Manish. Manish, what I would suggest is you can go on till slide number 20. Then I will
Right.
quickly give one or two comments. Then we'll take questions.
Sure, sir. The next doctrine is void for vagueness. Under vagueness doctrine, a statute is void for vagueness if a legislature delegation of authority to judges and administrative is so extensive that it would lead to arbitrary prosecution. Now, the doctrine says that when a provision is vague, in its sense that the result of it would lead to so much discretion, would be made, would enable a delegative authority so much exercise or enormous power that the result would be absurd. The maximum result would be absurd. So there is no guidelines, there is no policy, there is no regulation by the legislature, and a whimsical power is given to a delegatee that he could exercise anything, then the court have usually interpreted that when so much enormous power is given uh, to the delegatee and he exercises powers in a arbitrary way, such that in one case he's answering a question before him in certain way, and then there is another case he's answering question in certain other way. So it would lead to a common perception among the other industry and among the other trade that he would do so much, or he would do so much compliances, and he would do any sort of effort in complying with the law. Anyway, he is not able to ascertain his position before the authority. That authority would come out with some grounds or the other that it would make him derogatory, and it would the authority would make the taxable person responsible for some non-compliance or the other. So it would lead to discretionary and excessive arbitrary exercise by the delegatee, and therefore, since it is vague exercise, it would be void in law. Now, the Kartar Singh versus State of Punjab is a landmark judgment in this context. It says it is a basic principle of legal jurisprudence that an enactment is void for vagueness if its prohibitions are not clearly defined. Vague laws offend several important values. It is insisted or emphasized that law should give the person of ordinary intelligence a reasonable opportunity to know what is prohibited so that he may act accordingly. Now, if I see that section 171 prescribe that no, the anti-profiteering it is not, it, the profiteering exercised by any person is not condonable. And if he does profiteering on account of implementation of GST, then the authorities and administrative or executives would come after him. Now, in that background, a person of reason, a rational principle would definitely would try to comply with the provisions of section 171. But if there is no guidelines and there are no prohibitions at all on the exercise of powers by the NAPA, then how would he comply with this section 171, and he would ensure that the passing on the benefit ensures him immune from any action by the authority? Because if you see, the authority in some orders have held same set of facts in a certain way, and same set of facts with respect to one SSE in a certain way and with respect to another SSE in a different way. So how would a rational person would determine that if an action comes upon him, then the authority would decide the case in the one way or the other? So if it complies with the profiteering clause in one way, the authority would come up that you have not complied with the second way. So it would create a vagueness in the exercise of the authority by NEPA. And on this ground, probably the section 171 could be challenged for being void for vagueness, as it says subsection 3a also imposes penalty on the registered person. So whether this cancellation of a registration is also a havoc upon a person. He is not able to secure himself. He may try any effort, he may put in any effort on his own end, but still he is not sure as to what the guidelines are, so that he would be able to comply with those guidelines. In the absence of guidelines and in the arbitrary exercise of powers by Napa. This whole section appears to be falling voice to the doctrine of void for weakness. But this doctrine of manifest arbitrariness, I would like to time spend upon, and I'll leave it for the moment. And if we have time, I'll discuss the principle within the time availability, time suitability. The next doctrine is doctrine of reading down. Often a dispute comes before a court as to balancing the constitutional validity of law and at the same time absurdity of the application of law. When a legislature whose powers are not unlimited enacts a statute, it is aware of its limitation and in the absence of expressive intention of a clear law language to the contrary, it must be presumed to have implied into the statute the requisite limitations and conditions to immunize from the virus of unconstitutionality. So the court accepts that there is a presumption of constitutionality in the provisions of law because the legislature is wise and it understands the constitutional restrictions. Now this doctrines comes when a constitutionality is preserved by the court, but at the same time the whimsical the strict interpretation of that law would bring out absurd result. So if I would say this doctrine of reading down uh, infers gives power of the court to interpret a particular provisions in some modified way so as to exclude or so as to apply this provision in one case with respect to certain condition. So if I would say this doctrine can be applied in limited situation, it is essentially used first for saving a statute from being struck down on account of its unconstitutionality. It is an extension of the principle that when two interpretations are possible, one rendering it constitutional and the other making it unconstitutional, the former should be preferred. So if I would say when a provision in the ITC section says that the person would be entitled to receive would be entitled to claim ITC only if the tax on the same has been paid to the government. Now it would include all those persons, even those persons who have bona fide cases, those persons who had dealings with the bona fide sellers. Now because merely for one reason or the other, for a bona fide reasons, the selling dealers might not have been able to deposit the tax. Now, whether these provision of the strict provision of law, because it would better those bona fide purchases also within its ambit. It would carve out, it would include both bona fide purchases and other purchases within its ambit. Now, the whole intention of this provision was to ensure that the people do not take ITC on bogus or on mischievous transaction. If this application is taken to a large extent, then this whole object would be lost. When this object would be lost, that it would be succumb to being declared unconstitutional. So therefore, what the court usually does is to save it constitutional, make it save the constitutionality of it by reading this provision as it is, and it carves out those cases out of its ambit wherein the bona fide cases where the persons have been able to indicate their bona fide. So if I see this section 9(2)(g) of the DVAT Act, which also was probably similar to what we have today in section 16(2)(c). So the Delhi High Court in Onquest Merchandising India Private Limited versus Government of India read down the provisions of section 9(2)(g) of the DVAT Act to limits its action only dealers whose purchases were not with bona fide dealers. So it carves out the bona fide dealers from the rigor of this section, and for the reason being to save it from being declared unconstitutional, and at the same time making it the completely absurd provision. So probably this doctrine of reading down is very helpful when a court by this doctrine, the court avoids the observed result, and at the same time, it also preserves the constitutionality of the law. Also, so section 2C, 16(2)(c), where the probably where it says that the tax should have been paid to the government. Probably this rule section could be challenged by bona fide purchasers on the ground of reading down. Then there is the concept of public interest. So more often we see that the statute mentioned that any notification under a particular statute should be issued in public interest. So when what a public interest means is an act. One second. So public interest means an act beneficial to general public. Any exercise of an act in public interest means it is made applicable, keeping the public in large, considering the public in large. If an act is only caters to one person or the other, it does not fulfill the criterion of the public interest. It means an action necessarily taken for public purpose, means of concern. The public interest, which I'm interpreting, which I'm trying to interpolate now, is interest means action necessarily taken for public purpose, means of concern or advantage to public as a whole. In a recent case of Agrochem Federation of India versus Union of India, the government of India deleted the Kolkata High Court from the list of designated ports from where importers could import pesticides and insecticides. Now, this question came up before the High Court of Calcutta, wherein the Calcutta High Court held that when you have deleted Kolkata port from the designated ports, so not only it has achieved the purpose of controlling those unscrupulous persons who were trying to import clandestinely, but it has also impacted the public at large. So when you made that provision with respect to only considering those persons, those unscrupulous persons, you have basically ignored public interest. And therefore, the court struck down this deletion of Kolkata port from the list of designated ports with respect to import of insecticide and pesticide. In essence, the court allowed that the Kolkata port could be used for import of pesticide and insecticide. So when I see that, if I compare this rule 36.4, we all understand, and rule 86 of the GST rule for that matter, we understand the intention of the government is to catch up to those persons who are dealing in bogus transaction. It is very much clear from their intention, it is very much clear from their press notes and all those. However, they have not subscribed to they have not provided any substantial safeguard, so that bona fide purchasers are able to distinguish the course of this action. The executive authorities have immense power to apply this rule 36.4 and 86A with respect to bona fide purchasers also. So it could be said that when notification was issued implementing these laws, these rules, it might not have been the case that public interest was being understood or was taken care of. I'll pass it to Naveen sir for brief comments, and probably we'll take up the questions for the first session. Naveen sir, if you
Yeah,
could take it from.
yeah.
Yeah.
Thank you, Manish. Just two quick points. One on doctrine of void for vagueness. I would take the example of the definition of service itself, which is vague because it says anything other than goods. So you can include anything and everything under that, and that would lead to a lot of difficulty. So this doctrine can be looked at. One more thing is the doctrine can be applied also in the context of government service, where reverse charge mechanism is thought to be applied. Now, first of all, service definition is not clear. And when it comes to government service, it is not clear whether public functions are covered, whether sovereign functions can be taxed. So this principle of doctrine of void for vagueness, coupled with the doctrine of reading down, can be applied to interpret the definition of service and also the government service. One more example is when we interpret the price of supply related provisions in the IGST law. Since the CGST Act and all the other laws limit the applicability of the Act to India, which includes in state of Jammu and Kashmir. And we saw last week under the Constitution, you cannot the parliament can make law having extraterritorial operation, but it cannot extend to territories beyond the country. So therefore, while looking at place of supply provisions, the doctrine of reading down can be applied. I'm sure it will be employed by the courts in future. Yeah, now I think we can take some questions.
Right, sir. Rashmi, we have some questions, right? Rashmi, do we have some questions or we could continue for the? Uh, well, is there? Divya is there also, right?
Yeah.
Yeah. So Rashmi, do we have some questions? Because this half an hour in the first, we could probably take them up.
Yeah, nobody has posted any question currently. That's what if
Okay.
anyone wants to ask, they can post. I'll read out the questions.
In
Right,
the meantime, you complete those pending slides, Manish, on
right,
arbitrariness.
right, right. In fact, sir, for arbitrariness, I would take it up in the last, depending on upon the time we have, because
Okay,
that
fine.
I want to spend some time on. So in the
Okay.
meanwhile, we could, yeah, thank you, sir. So we can discuss tax planning versus tax evasion. Now, the difference between tax planning and tax evasion has been the thin line of this difference has been uh, evaporating over the time. Sometimes, I mean, it is get diluted. It sometimes it get increased. Sometimes it gets reduced to negligible. So we could have some commentary over this from the judgments of the past that are landmark judgment and see where the difference could be made upon. So the landmark judgment with respect to tax plan and tax evasion stems from the England, the House of Lords in IRC versus Duke of Westminster. It is commonly known as the Westminster Principle, wherein the House of Lords had held that every man is entitled to order his affairs or arrange his affair within the legal framework so that the tax attaching under the appropriate act is less than it otherwise would have been. So the court held that a person is entitled to arrange his affair, and in such way that although the legislature was trying to attach some tax upon him in certain way, and if he comes out of that certain way by arranging his affairs, he could escape from the tax liability, because the provision of law, as barely read it, would not enable the legislature in imposing in attaching tax from in text from him in by the bare reading. So this principle was a very large principle wherein every person was entitled to arrange his affair, and the court would not see what the substance over the form was until it in fact it was it started from the England and then adopted by the Indian courts for so long that the Indian courts also used to see how the tax statute barely read it. The courts would not impede upon what the intention of the assessee was. They would not come to a the removing the window of they would not adopt a look through approach. They would adopt a look at approach and see what the provisions are and decide the case depending upon those bare provision. In McDowell and Company Limited was the CTO. However, it was a kind of distinction that was made out by Justice Chinnappa Reddy. The case was in the context of sales tax statute, and Justice Chinnappa Reddy wrote a different opinion, and it says it departed from the Westminster principle, and it basically imbibed morality into the taxes. So the justice said the test to construe tax statute is to ask whether the transaction was a device to avoid tax or not. So it says whenever a taxation statute is interpreted and a person is coming up with his arranged affairs, the court should also look at whether a device was formulated just to escape the tax liability. It said that wherever a colorable device, so long even if that colorable device might have been relevant, might have been legal under the legal framework of the law, then also the exercise by the person would tantamount to tax evasion, and he would not be allowed to go further, and his exercise would be held invalid. So the court, the Justice Chinnappa Reddy basically formulated a different perspective. It says that you have to see substance over form also. Now, because this opinion of Justice Chinnappa Reddy was a distinctive opinion, it was a minority opinion, 4:1, the one minority opinion. It was not concurrently agreed by the courts over the years that it is the universal law. However, going forward, there was contradicting decision as to the exercise of creating a difference between tax planning and tax evasion. Some courts would subscribe to the view of Justice Chinnappa Reddy and say that you have to see whether there was a culpable device or not, and some court would just read the law on a bare reading. Now, in case of Union of India versus Azadi Bachao Andolan, this principle, Westminster principle, came into debate also, and the court held that Westminster principle was still alive, and that Justice Chinnappa Reddy's judgment was not agreed upon by the majority. The view of Justice Chinnappa Reddy somewhere just militated into the entire judgment. So, therefore, this judgment of culpable device is not so much universal that every time a court would look at how the principle what is the intention by the claimant was in coming up with this arranging of his affairs. It says that you have to limit the law laid down in McDowell, and not in every case this substance over a form or a culpable device would be applicable. This basically held that every facts have to be seen on their individual application. In Supreme Court in Vodafone India Holdings BV in 2012 case, it was an income tax case, also observed that Westminster principle is not completely discarded, but to be discarded only in the context of artificial and culpable device. It focused on the look at principle, which was also held by House of Lord in Ramsay. The court also noticed a very key difference in the interpretation of Justice Chinnappa Reddy, in which the justice had that observed that the Westminster principle was in fact discarded in the country of its origin itself, in the England itself, by some subsequent decision. So the Supreme Court in Vodafone India Holdings held that this decision was not discarded completely, but the ramifications of this principle in subsequent decisions was clarified. So the basic presumption of Justice Chinnappa Reddy that this principle, this Westminster principle, was discarded was incorrect, and therefore the court held that the principle of Westminster still prevails, and also focused on another House of Law judgment in the case of Ramsay 1981, that the court should only look at the look at principle. It should not go down beyond the window and see what the intention of the law was. Again, we have some contradicting decisions, but there was a line forming as to how this court might have applied these principles of tax evasion and tax planning. BGFT versus Connect Exports, the Supreme Court had held that artificial inflation of the export turnover of status holders by including turnover of other exporters resulted in culpable device to claim higher scrip. So the status holders were inflating their export turnover by making third party export on behalf of some other exporters. So they were inflating their export so as to claim higher scrip benefit. Now, the court held out there is no problem in arranging of the affairs by the companies. However, at the same time, they cannot come to a fraud with the law. They cannot come to a fraud with the constitution. They cannot come to basically achieve what was not intended to be achieved by the court. If achieved by the legislature, if the legislature grants you some benefit, it is an assumption that you would subscribe to the whole basic condition of those schemes. If you try to overcome those conditions and make it some collusive device, some mechanism to just come to the beneficial clause of those schemes, then it would not be applicable for the persons to claim those kind of benefits. And in that case, to Connect Export, the Supreme Court also highlighted this colorable device mechanism, this color device concept of tax evasion. Now, in the context of it, a question could be asked whether the incentive policies, which earlier were, wherein earlier the state legislature would use to grant sales tax exemption based on the intrastate supplies and interstate supplies, because earlier the state government was getting sales tax both on interstate and as well as intrastate sales of goods. Now, since many states have, upon the implementation of GST, have restricted the sales tax exemption only on the basis of their intrastate supplies. Now, in doing so, the persons whose majority of the sales were interstate supplies have seen their benefits come to a halt. So they have, can they do can they arrange their affairs in certain way that they would insert another chain in their supply chain and insert a position, insert a person, be it agent or a distinct person, so as to make their first stage interstate supply as interstate supply, and then claim the benefit of sales tax, the benefit of GST refund basis their now converted intrastate supplies. Would those arranging of affairs would be labeled as colorable device? It might not be so, because the whole intention of granting those benefit by the state legislature is that you invest your machinery, your property in the state, you employ sufficient number of local persons, and then if you satisfy these material conditions, then you are entitled to certain percentage of sales tax or GST refund benefits. Now, because since merely because GST was implemented and this scheme was impacted the calculation of the benefits by them, would the arranging of their affairs would be labeled as device, because they had satisfied the material conditions. Now, in doing so, it not be said that they have employed a colorable device, because they are only altering their affairs to get the benefits, to make themselves compliant with a particular law. Probably these cases are the cases where the judgments in Vodafone Holdings and Westminster principle could be applied. Now, having said so, just recently there was an AR by the income tax AR in the case of Flipkart case, wherein the AR basically declined to accept the application, advancement application, on the premise that the whole intention was to um, uh, you know come out with a tax evasion practice. Now, whether this scheme of tax planning as tax evasion is demarcated, clearly demarcated, has somewhat been confusing, so as to say. So we should be very careful and cautious to arrangement of all our affairs, because this is indirect tax that we don't have the precise anti-abuse mechanisms, unlike the Income Tax Act. But there are sufficient provisions under the GST acts, like you have the restrictions on the ITC, you have some words that are there in the act, like the furtherance of business. All these words could be used by legislature and the court to say that these are anti-abuse provisions and arranging of affairs are hit by these provisions. So probably this tax evasion and tax planning case should always be examined whenever a question like these are has to be interpreted. Naveen sir, if you could have your views on this tax planning tax.
Yes, Manish. Um, See, this tax planning and tax evasion, there is always a debate on that, and there is a thin line of distinction. But at the same time, we should understand that government is not a partner in business, and I need not do my business to ensure that government gets maximum tax revenue from me. That is also a settled position. But wherever illegitimate tools are employed, dubious tools are employed to create certain things which results in evasion of tax, the government can always come down on those people. Even courts have been very strict while looking at those type of cases. There are instances where corporate wheel has been removed. There are instances where units were treated as paper companies or dummy units, and clubbing has happened. We have seen that in the excise context also. And now in the context of GST, the circular trading, which results in large scale evasion, the long arm of law always catches them. And at the same time, we should also look at one more important aspect. That is, the courts have also said that when interpreting the taxing statutes, we need not look at the morality aspect, because in law we are concerned with the legality and not morality. Even Justice Kadju said that in some judgment. So in Martin Lottery's case, the question was whether lottery should be taxed or not. The court said that don't look at whether lottery is something wrong, morality, all those things are not relevant. We are just interpreting the provision, that explanation which was added, whether it is prospective or retrospective. So that is that is the way in which you should look at the law. Manish, over to you. I think you can finish the next 3 slides on legislative competence, and then we can have a break.
So we have one question, so probably we could answer that and come
Yeah,
to a
sure.
break. And I'll complete the relevant slide because they would not be taking so much of the time. So the
Okay.
question, yeah. So the question is, concept of mutuality is on the concept of mutuality. So the question is, can we apply the tax, this concept to say that tax on supply between distinct persons should also not have been taxed based on this constitution? This doctrine of mutuality. So it says you have created distinct person under section 25(4). So whether this doctrine of mutuality could be applied in those cases also. Would you like to
Yeah.
answer that, sir?
You
Yeah.
you go first, then I'll give my views.
Okay, so probably in my view, whatever the court had deduced in the Calcutta Club Limited judgment, that you have to make the person different. So by making the persons different under section 25(4) very precisely, it would be very difficult to say that this concept of mutuality has not been overcome by the legislature. But having said so, there is one room of leeway, that in this judgment, the court had relied upon one income tax provisions where the word mutual insurance was specifically highlighted. So the court was so ardent that it was that legislators should use the word mutual to create a distinction between the persons. Probably it was a bit exaggeration, but yes, there is some very small leeway in saying so that this distinct person, in the context of distinct persons also, this concept could be advised. I would not conclude by saying that this should be advised to any client, but yeah, there could be there anyway, since the judgment is very specific on those words of income tax statute. um, it could be interpreted in such a way also. Naveen sir, over to you, sir.
Yeah. See, the basic, if you look at the past regime, in the either in the service tax law or in the context of CST, we did not have this difficulty at all. I could transfer my goods from one branch in a state to another branch as long as I was able to produce some forms. It was usually not taxed. Stock transfer, except where there is a predetermined sale, etc. So I come to service tax also. This type of distinct person concept was not required at all, because service tax law was a union law, and any transaction or any activity between the branches or head office, they did not think it necessary to have this type of a distinct person, because ultimately revenue goes to the union. But in this GST, the peculiar situation is you have the state and center joining together and levying a simultaneous levy. So therefore, there is a requirement in law to ensure that you determine the place of supply in appropriately, so that you see whether it is interstate. If it is interstate transaction, since it's a destination based tax, the money flows to the tax revenue flows to the destination state, unlike CST where it was the origin state. So similarly, in the context of service also, there is a requirement to determine the place of supply and decide whether it is intrastate or interstate. Now, as far as uh, this mutuality principle is concerned, I think this can be applied even in the context of GST law, despite the distinct person, uh, provision section 25. Uh, in fact, you can even go to say that you have to read down the provisions so as to ensure that the tax revenue goes to the concerned state. And I would also make an observation in the light of that Columbia advance ruling. They have drawn it to a very great extent and said that whatever, even the employee of a branch is not an employee of the head office, therefore it becomes taxable. So these type of interpretation using this distinct person concept would only lead to absurdity, and we are going to ignore, we are ignoring the basic principles of law, which would be questioned in the court of law. In fact, I had also pointed out Sir Kikabai Premchand's case. You cannot do business with oneself. It is like saying that your hand is doing service to your other hand or leg. So that is not the way to interpret. Branch is also part of the same organization, and this distinct person has a limited purpose. You cannot stretch it so far to encompass so many things to consider it as service or supply of goods. I think in the near future we'll have disputes on this. Thank you.
Uh, And in fact, sir, if you read that provision, again, it does not say that I am deeming a branch and a head office or different branches as a different person. It merely says that registration in different states are different. So there is always
Correct.
a room for the language, language abuse by any person. So yeah, it could
But
be. See, we would see over the course of time. Yeah, right, sir. So I think Rashmi, we could have a break for 20 minutes and then probably come back at 11:50 for the rest of the session.
Yeah, yeah, sure, Manish.
Okay. Yeah.
So we'll be breaking now and we'll be resuming back by 11:50 then.
Right.
thank you.
Okay, thank you.
Hello, Manish?
Yes, sir. I think we can restart now.
Yes.
Okay. So, welcome back, everyone. We will be just completing the rest of the doctrines very shortly, and I request everyone to put up the questions if they have any on the chat box. We have reserved half an hour of this second session for Q&A only. So, meanwhile, we just continue with our pending documents. Legislative competence is one of the, I would not say it is a doctrine, but it is a principle of constitutionality. It has been very celebrately accepted by all the constitutional benches of the Supreme Courts and other benches also, that there are two unfettered grounds on which a constitutionality uh, an act could be struck down on account of constitution, could be challenged on account of constitutionality. One is the legislative competence, and the other is uh, provision or the subscription to fundamental rights under Part 3 or any other provision of the Constitution. So the first principle is that the legislator which is enacting an act should be legislatively competent. Now, this legislative competence to enact an act stems from the finance part of the constitution, which says Article 245 to 45 to 46, 46A to 44 to 48 to 53 to 54. So all these articles basically say that the state legislature and parliament within their respective jurisdiction have the power to enact a statute. Now, as we had seen in our earlier discussion on the Constitution, 246A is a little departure from the common field of legislation that Article 246 provides. 246 provide all the powers that can be exercised can be put into a statute. Now, the when a question comes into before a court as to legislative competence, it is largely with respect to a state legislature, because in a constitution, as per our constitution, the parliament has immense power. It has residual power. It has immense power. It has overlapping power in certain aspect also. But the state legislature's power is only restricted to the second list, that their state list, and the concurrent list, provided the restrictions therein, and provided the union has not exercised their powers on the any aspect covered on the concurrent list. So it is usually seen with respect to state legislature, whether the state legislature, an act of state legislature, is in with the entries that are provided in the state list 2 or not. There have been often been questions on the state's power to legislate on electricity, the interstate course of supply. There have been um, disputes with respect to land and buildings, with respect to power of the state to impose taxes on land and buildings. There was workers' compensations cess that was imposed by the state earlier in the past, that was also being disputed. Then there is lottery, the tax on the lotteries that has been over the course of period that has come to the dispute before the court to comment upon. So over the courts have basically formulated the legislative principle in very limited aspect. I'll quickly I'll discuss two aspects herein. One is the Article 246 and 246A, because these two has diverged the practice of how this legislative competence should be seen. When it comes to Article 246, in determining the state legislature competence, we only have to see whether the act honors the power that have been conferred upon a state within the list 2 or not. However, when it comes to a parliament, the only restriction that in fact, what is the power of the state when it comes to legislative competence is itself becomes the only restrictions when it comes to the parliament. So when I say state does not have power to enact a statute with respect to state, I'll rephrase that. When I say the state has power to enact a statute with respect to entries listed in list 2 of the 7th schedule of the constitution, It also means the parliament cannot make laws with respect to only those entries which are listed in schedule in the list 2 of 7 schedule. Otherwise, Parliament has all the powers to enact a statute with respect to any subject. Now, when a subject is over, when a particular power is covered within the subject of a particular state legislature or parliament, now we have to see whether that state legislature or parliament are not overarching other provisions of legislative competence, which is whether they are exercising their powers beyond Article 245. Is it extraterritorial? Then we have to see whether these enactments are beyond the international agreements that India has agreed with international unions and um, international bodies like UN or IFAC. Article 245 says that these the provisions of this formulated under 245, 246, and 246A are not applicable with respect to these to the with respect to the international agreements to which the Indian party to which India is party to, and under which they are supposed to exempt those entities from the rigors of these statutes. So we have legislative competence with respect to 246, one with respect to 246, and now with recently this since 246A has been enacted by the 101st Constitutional Amendment Act, we have another set of returning. We have another set of questions as to how to see the legislative competence under 246A. Now, because earlier we were simply saying that the legislative competence should be seen with respect to uh, the entries in the list given in the 7th schedule. Now we have some different kind of legislative competence barriers under 246. It is settled with the enactment of 246A that both state and center can enact a law with respect to goods and services tax. However, what else is the legislative competence with respect to 246A is that has been defined or somewhere provided by the Gujarat High Court in Reliance Industries Limited case. Now it says state cannot use 246A to enact a sales tax statute. That is, sales tax statute was provided under Anti 54 with respect to products other than petroleum goods. So therefore, under 246A, state cannot go back and enact a statute in respect of sales tax in the nature of sales tax act. Second, the court says that while 246A is there, it has to be circumscribed by the provisions of Article 269A. It has to be subject to Article 286A, 286 also, wherein 269A says that interstate supplies the state cannot levy a tax. Simply, similarly, under Article 286, 286, the state legislature cannot enact a tax on a supply which is occurring outside the state, or on a state on a supply which is in the interstate which is in the course of import or export out of India. So therefore, test with respect to 46 and 246A are different, but the key intention is that whenever a statute is being enacted, state or legislature, the parliament should have the legislative competence to enact the statute. Now, we have discussed all these flaws in the section in 19 of the 101st Constitutional Amendment Act in our earlier presentation, so I will not be discussing much on that. But I would say some observation on this legislative competence is that this legislative competence should be seen on the date of enactment. Now, a case could be that at a time when a legislation was in force, a different government was entitled to make laws with respect to with respect to that aspect, and over the years with respect to changes in the constitution and powers the distribution of powers between state and center, it might be the case that earlier state was entitled to levy tax on on the sale of goods. Now it could be the case that center has become liable incompetent to levy tax on the sale of goods, because we have a lacuna here also that under entry 97 of the list 1, a center could levy tax on any aspect which are not covered in list 1, list 2. So therefore, can it be argued that the center has power to enact a levy under a levy on the sale of goods in the course of intrastate sale of goods or not? We have some indication flowing from Article 248 that entry 97 has to be subject to Article 246A. However, at the same time, can you interpret entry 97 in such a way that fragmentation of supply cannot be done with respect to sale of goods, sale of services, supply of barter exchange? Can it not be done by center? It is a question of uh, large comments by a superior court. So we have to see those questions burning in the future course of time. We have some amendments, as we had earlier seen in our earlier presentation, that Gujarat VAT Amendment Act was struck down uh, uh, for being not state being not legislative competence to enact that those Gujarat VAT Amendment Act. Similarly, the state of Maharashtra and the state of Goa have amended their VAT Amendment Act to provide for the validation of acts which were invalidated by the courts. So the similar question could be asked with respect to these Ordinance and VAT Amendment Act also. Uh, we have discussed the other aspect of of legislative competence in our earlier presentation. So I'll come to next doctrine, which is the Validation Act. The Validation Act is basically uh, removal of errors that have been notified in a particular judgment or a decree of a court. It is settled or rather accepted principle that when a statute has legislative competence to enact a statute, it also has the power to make statute with retrospective effect. Now, this retrospective power is often exercised by the court to rectify the error in the legislature that has been identified by the court. So when an error is identified, and to make good of the error, the legislature ends up enacting another statute. That statute, the subsequent statute is generally commonly known as Validation Act. It validates the act of previous actions that have been committed by the state legislature with respect to earlier erroneous power. Now, this Validation Act grants those power, makes those power as valid power. The Black Law Dictionary defines Validation Act as a law that is amended either to remove errors or to add provisions to conform to the constitutional requirements. In Amrinder Kumar Mahapatra versus State of Orissa, the Supreme Court held that but when the validity of such a validation act is called into question. So in this case, the court was defining whether what is the constitutional challenges with respect to validation act. Now, earlier an act has been declared unconstitutional. Now the court is commenting upon whether this validation act is constitutional or not. So it says the court would have to carefully examine the law and determine whether the vice of invalidity that rendered the act, rule, proceeding, or action invalid has been cured by the validated legislation or not. Whether the legislation were competent to validate the act, action, proceedings, or rule declared invalid in the previous judgment, and whether such validation is consistent with the right granted by Part 3 of the Constitution. So it basically applies all those common principle, first principle with respect to Validation Act also. And another principle that has been applied is whether the Validation Act has itself cured the earlier defect. It may happen that at some times that the error that was identified in a judgment was something, and the Validation Act, in the guise of removing that error, has done something else. So court examine whether this Validation Act is proper or not, whether it removed the error or not. Merely by the government promulgating an act does not itself factor um, you know uh, rectify the error of pointed out in the judgment. So Krishna Murthy was the state of Madras is another example. It says if a law passed by the legislature is struck down by the court as being invalid for one infirmity or the other, it would be competent to the appropriate legislature to cure the effect. So it accept that a cure can be accepted. Now in Reliance Industries, as we had earlier read that Section 84A of the Gujarat VAT Act amendment, Gujarat VAT Act had excluded limitation period, excluded the time taken before the judicial remedy from the limitation period prescribed in the Section 75. So the court held down that this the cure that has been affected by Section 84A has not cured the error of that were pointed out that were there in the law. So it says, although you have granted a limitation, extended limitation, however, by merely providing a limitation period, you cannot reopen the old vested right, reopen the already assessed cases. Section 84 does at no place revive the concluded cases. So this your limitation period, that extended period of limitation, would only be applicable with respect to the unconcluded assessment, and validation act is limited to only those persons whose assessment have not been completed. It is has not completely rectified the error pointed out in the earlier judgment. Now in there was we have seen the case of Siddharth Enterprises and brand equity recently by the Delhi High Court, wherein it has been held by the courts that uh, the time limit of filing Tran has not been prescribed by Section 140. Now we have seen that Section 140 was amended to provide for the time limit, and recently it has been notified also. So the question could be whether this limitation act, this provision of section providing time limit in 140 has validated all the acts, or should it be construed only with respect to uncompleted assessment of Tranman? So if I say that 140 provides me a time, but whether it also revives the Tranman that have already filed, it probably doesn't appear to, because Validation Act only gives time limit to a particular rule. It does not revive the Tranman assessment. So therefore this validation act should at all not be applicable in respect of those assessment where the Tranman has been filed and scrutinized by the offices. uh, in a customs, basically there was very crucial judgment, or I would say a crucial dispute that has been pending. In Sayyid Ali case, the Supreme Court had quashed the show cause notices issued by the preventive and DGCI wings for them not being collectors of customs and not being proper officers under Section 28 of the Customs Act. Now, this Section 28 was amended by the Validation Act of 2011 by inserting subsection 11, wherein all those officers, it said that, shall be deemed to have and always had the power of assessment under Section 17. Now, this dispute came over before Delhi High Court in Bengali Impacts Limited, wherein the Delhi High Court examined whether the subsection 11 has cured the defect pointed out by Sayyid Ali or not. It said that although you have provided some section 11, subsection 11, that these are deemed to be assessment, that these officers of DGCI and preventive are deemed to be proper officer under Section 17. However, when you see Section 17, proper officer under Section 3 of the Customs Act, it says the proper officers have a jurisdiction with respect to each assessee. Now you have treated all the bunch of officers as a proper officer, unless you carve out the jurisdiction and you based on some area or based on some other rational principles, they ipso facto do not become proper officer with respect to the assessee. So therefore subsection 11 has not cured the defect pointed out in Sayyid Ali. Now, this view has been dissented by Andhra Pradesh High Court in Upalamaritha, and of course, this appeal against Delhi High Court decision in Bengali Impex is pending before Supreme Court. Now, if we see the validation done by amending Rule 61 of the CGST rules, wherein the central government has tried to overcome the AAP and Company judgment rendered by Gujarat High Court. Now, if we see in the AAP and Company High Court, the Gujarat High Court had held that the press release restricting ITC beyond September 2018 for the for the financial year 2017, it had ruled upon two aspects. It said that this press release is ultra vires to Section 16(4) of the CGST Act, in as much as the due date of Section 39 one has not been expired. Why Section 39 return has not been expired? Because GST 3B was never required to be filed. Then subsequently, it held that GST 3B is not a return under Section 39(1). Now it is, they have amended Rule 61(5) of the CGST rule by saying that GSTR 3B is a return under Section 39. But whether this provision, this amendment of 61, at the same time remove the effect of Section 39, whether it says that that the time limit under Section 39(1) has been deemed to be expired with the filing of GSTR 3B, because if you see, they have not specifically stated that GSTR 1, 2, and 3 would never be filed if GSTR 3B is filed. They have still called it as this GST 1, 2, and 3 are still being, the mechanism under 1, 2, and 3 are being kept in abeyance. And so unless this GSTR 3B is still alive and that return GSTR 3B continues to be a return under Section 39A, how can it be said that the first defect that was pointed out by Gujarat High Court in AAP and company has been cured? So probably on this aspect, this question could be challenged. I'll invite Naveen sir attention to two doctrines, two principles: legislative competence and validation.
Thank you, Manish. Just two quick pointers on legislative competence. The latest decision which the participants can look at is Mohit Mandel's case, which discussed this legislative competence in the context of validity of compensation cess. Then, as regards the Validation Act, again, I would draw your attention to Sheen Golden Jewels, where there is a discussion about the effect of Validation Act. It was a case relating to Section 174 of CGST Act versus Section 19 of the Constitutional Amendment Act, which we discussed in the last session. And there's one more interesting issue which has been referred to the larger bench by Supreme Court in a case of Deccan Cements Limited, which was in the context of cess on minerals. There, the court raised a doubt whether through a validation act, it is permissible to introduce a levy. That issue has been referred to the larger bench of the Supreme Court in Deccan Cements case. That's all. You can continue.
All right. Next, we come to the principle of noscitur and soci. So it says where two or more words which are susceptible of analogous meaning are coupled together, they are understood to be used in their cognate sense. They take their color from each other. The meaning of the more general is restricted to a sense analogous to a less general. So it says whenever there is an ambiguity in interpreting the provisions, the words of a phrase or a sentence, we can apply this principle to say that these ambiguous words in that sentence are taking color from the surrounding words. If I say that a phrase defines the words bread, butter, ghee, etc. So what this etc. means? Does it etc. means all kind of goods? Does it mean television, fridge, mobiles also, etc. also? It might not be, because the courts have interpreted this provision as if that etc. should be read analogous to the corresponding words in the company of its words. So when it says bread, butter, and ghee, it means a class of words which identifies as a dairy products. So etc. should be restricted only to the dairy produces goods. It should not be expanded to include all other kind of goods that are not prescribed therein. Now, this principle is widely accepted by court for interpreting tax entries in a tax schedule. In Pradeep Agarbatti was the state of Punjab, it was held that entries in schedule of sales tax and excise statute list some articles separately and some articles are grouped together. When they are grouped together, each word in entry draws color from the other words therein. This is the principle of non-seriality. So it says In a tax schedule, you have two kinds of entry. One is that there is a limited expressions, and then there is a class of expression. In the class of expressions, you have to necessarily apply the principle of necessary association. Now we have some exclusions to it. Now, it is not permissible to exclude by application of. I'll take 1 second. Excuse me. Yes, I'm back. Nociteur associate has some exclusion to it, and at times when the intention of the legislature is very wide to prescribe that they're encompassing a large spectrum of things. Now, if the intention is very much clear, then you cannot apply that principle to say that I'll be using this nocitarian sources and interpret the word with respect to class of those products. This was held by the tribunal larger bench in Union Carbide. Nocidiarus associ has an extended arm, which we commonly known as adjunct generis. Now, adjunct generis is a branch of Nocidiarus associ, and in Amber Chandra versus Collector of Excise, the court laid down certain uh, condition as to when this principle of adjunct generis should be applied. It says the statute contains an enumeration of specific words. So if I'm saying that bread, butter, and ghee, there is an enumeration of specific words. The subjects of enumeration constitute a class of category. Now, if I say these specific words are construing as a class of a particular category. If I say that these words, if I read do bread, butter, fridge, mobile, motor vehicle. Now these expressive words are not indicative of a particular category. So in that case, a adjunct generis fails. Then the class or category is not exhausted by enumeration. Now it also says when you defining certain words, it should not be that so much large number of words are entered such that they are exhausted. You cannot think of any words which might have been covered and is not covered. Then it says the general terms follows the enumeration. Now the general terms are etc., all, else. All these words should be followed by specific words. There is no indication of different legislative intent. Of course, this has to be seen. Now, we have certain case studies into it. In a customs case of Amazon India Private Limited, this Amazon Kindle was examined from the perspective of a customs notification, rate notification, which provided lesser rate of BCD on the description falling under electrical machines with translation or dictionary function. So this Amazon Kindle basically has the features of translation or dictionary, but these are not its primary features. So the court interpreted that this translation or dictionary functions are basically the primary intent of these the intent of this entry. Now you cannot interpret the words to say every kind of a category would have with these features would fall into this taxation entry. So this is basically a broad line of when a nocitera associate is applicable and when it is not applicable. So in of course this Delhi High Court had held that this Amazon Kindle, which does not have the essential, the primary features of electrical machines and translation, sorry, the Amazon Kindle, which with whose primary feature are not translation or dictionary, but some other features, then it does not fall within that taxation entry. Now, if we look at certain clauses of GST Act, if you see Section 75, 5 clause C and D prohibits availing of ITC with respect to construction activities. Now, the construction activity exclude plant and machinery. Plant and machinery itself has an exclusion that it does not cover. First clause I'm talking about exclusionary clause, that it doesn't cover land, building, and other civil structure. Now, how you construe this other civil structure word? Is it that all civil structure words would be excluded from the definition of plant and machinery? We have the example of ETP plants, we have the example of water tanks, the earth dig water tanks. So whether can I say that this civil structure should I read with respect to this land and building only? Because if I give you an example, a water tank dig in the earth, should we call it as a civil structure? Now, if we see, read it, nocitera associate with land and building. The water tank dig in the earth with concrete and some instrument. So it doesn't appear to be a land in ipso facto, because it is a civil construction. It is made up in the land. It is not land in its sense. Then it is not a building also. Building has a superstructure with it. Now, the water tank does not have a superstructure. It is only a hole in the earth, and it is not weighing, not taking the weight of any particular thing or something. So the water tank does not appear to be a land and building in its strict sense. So should you call these water tank as within the purview of other civil structure? Because at the end of the day, if I ignore the land and building interpretation, then this might have been fallen under the purview of this other civil structure. Because at the end of the day, every civil construction is a like a basing a foundation on a concrete and filling up the instrument so that the structure could be made, a foundation could be made. So if not read nocitera associate, this might fall under other civil structure. But of course, we have to see how this is in this exclusion entry is interpreted. This cases omissus is a principle stemming from harmonious interpretation of law. At times, there are cases when a law does not provide for a particular situation. It might intend to, but with the drafting error at sometimes it may happen that legislature might not include those words. So casus omissus is a case where the court supplies a language to omitted word to make justice to the interpretation of that provision. Uh, an omitted case is a statute is unenforceable. It is a case of omission, but in order to supplement the situation, the court needs to fill that omission. It is a canon of construction as we know it, requiring the court to draw up the principle of statutory construction, which are then going to be followed by subsequent judges. So this cases omissus basically forms a situation where a law is made by the court, not in its strict sense, but in the interpretation sense. It basically sets out that now a superior court is defining a words by adding words into the statute, and now going forward all the courts would take this judgment as a reference, as a binding precedent, and apply and interpret that statute with after considering the addition or deletion made by the superior court. Now, if we see in the Taj Mahal traders, the court highlighted the cautiousness in application of casus omissus. It says that casus omissus is a first principle which cannot be supplied by the court except in case of clear necessity and when the reason for it found in the four corners of the law, four corners of the statute itself. Now it says when seeing two, three provisions from the statute and it's seeing the legislative intent, it should not be applying cases omissus if the cases if the addition or deletion of those words is specifically being prohibited or intend to be prohibited by some other provisions of the law. We have the case of Union of India versus Dhamendra Textiles, wherein Section 11 AC of the Central Excise Penalty was in dispute. So an argument came in whether the mens rea should be supplied as cases omissus by the court. The court held that cases omissus cannot be supplied because the legislative intent was clear that all the frauds and suppression cases were supposed to be taken as if the mens rea was not think of as a necessary constituent by the legislature. Now we could have possible examples in the GST Act also, wherein Section 17(2) of the CGST Act, it does provide for allocation of ITC where the person has been engaged in partially manufacturing of or the supplying of partially taxable goods partially exempt or non-taxable goods. But does it cover the situation where where the taxable person is entirely making the exempt goods? Because if you see earlier under the SENVAT credit rules, there was specific provision for the partially taxable and partial exempt category, and the category where the person was exclusively engaged in the exempt manufacturing of goods or exempt provision of exempt services. So section 17.2 probably a good case where the court might supply cases omissus to say that this provision is applicable also where the supplier is engaged in wholly exempt supplies also. A possible interpretation in section 19.3 of CGST Act also be subject to cases omissus, because 19.3 says that when a job principal has supplied inputs for job work to a job worker and it does not come back to him or supplied within a particular time period, it would be deemed to be a supply. Now, when I say a supply, when a person makes available a particular goods to another person without consideration, it does not ipso facto become a supply under Section 7. So, how can Section 19 assert the jurisdiction on Section 7? Probably in this case, the court could apply cases omissus to restrict its language that supply would be deemed to be happened only with respect to where section 7 has been complied with, like where the job work was sent to a distinct person or to a related person where the consultation was not needed at all. Naveen sir, you would like to have your comments on nocitarian sources and
Yeah,
cases.
sure. One principle which I always remember while reading Nocitor Asosis or Agistum Generis is birds of same feather flock together. And when you read the general words which follow specific words, we always try to interpret the general word with reference to the company it keeps, that is Nocitor Asosis. And uh, one important judgment, recent judgment of Supreme Court was in the context of Kerala VAT in Parle Agro case, reported in 352 ELT 113. Uh, it was on the interpretation of an exempt, an entry relating to tax rate. Appy Fizz, which is a beverage, the question arose as to which category it would fall. So you can read the judgment of Parle Agro to understand how this principle has been used. Then coming to casus omissus, there is a decision of the Supreme Court in the case of Valliyappa Textiles, which was rendered in 2003, relating to income tax prosecution. There, the court made a pertinent observation. They said that the job of plugging the loopholes must strictly be left to the legislature and not assumed by the court. A court cannot breach a casus omissus, and no canon of construction permits the court to supply a lacuna in a statute, nor can courts fill up the lacuna in an ill-drafted and hasty legislation. Whether the omission is intentional or inadvertent is no concern to the court. So this is an important thing. One example which I can think of is if you look at the interest provision under section 53 of the GST Act, if you look at in the context of ITC, nevertheless it talks about excess availment, etc. But they link that provision, undue or excess claim of ITC, under 4210 or 4310. If you look at those provisions, it relates to matching concept. So the interest provision there specifically applies only in a case where you take undue or excess claim and where you don't pass the test of matching. So is it a case of case where the court can provide for words to say interest will be applicable in all cases? And if you see, these type of situations have arisen in the past also. Wherever I remember there were some cases decided by the courts, 50 in the context of Rule 57cc, which is equivalent to Rule 6 of the Senate rules. There was no mechanism to demand that amount. They said that it is not in the nature of duty, and you cannot use Rule 14 or the other provisions 57I, etc., to demand that amount. So then they provided for it by way of an amendment. So this is also a case, Section 53 has limited the interest liability to ITC to peculiar circumstances, which is a drafting error. And I don't think the courts can supplement or add something there. Over to Manish.
But do you see, sir, which are the legitimate cases where this principle could be applied? Because it is understandable that there is acceptance that this should not be applied in almost all cases, but probably there could be some cases. So if you could give us some understanding on that, sir.
I am not able to bring some case law at this juncture to show, but I read where the court has added something to the language and interpreted it. So the principle of casus omissus has been given a go by. Maybe as you are talking, I will try to locate some case law on that.
Right, sir. Thank you. Yeah. Right, sir. Thank you. Next, we come to nemo judex in causa sua. It says no one is judge in his own cause. The principle is an extended arm of principle of natural justice. Natural justice again stems from Article 14. It discounts all the bias that may crop up in adjudication of a proceedings. And this principle particularly says that, or is on the ground background that not only the justice should be done, but it should be seemed to be done. So the concept behind this is that there when you give an adjudication power to a person, now if at the same time you give him some the allegation power to him also, now since he's the same person, he would always see bias towards his own you know the cases that he himself has formulated. So probably this decision or this principle could be applied to say that an investigation officer would should not be made an adjudicating officer, so as to remove all the bias and ensure the principle of natural justice. Now in this TVL Steel Hypermarket Private Limited case was the CCT, the Madras High Court has issued an order. The dispute relates to the two circulars, where para 5 of circular number 10 by the Commissionerate, the Tamil Nadu Commissionerate, has authorized the state tax officer to conduct inspection under Section 67 of the TNGST Act. And while Section 72 has prescribed the proper officer under TNGST Act for carrying out various functions such as inspection, assessment, reassessment, adjudication, appeal, and review. So, in other words, the circular has authorized the same person, namely investigation officer, to sit as an adjudicator of those very proceedings that he has initiated. So, the argument before the court is it not liable to the principle of non-judex in causa sua, and is he not exercising his he's not violating the principle of natural justice? We have to see basically the application of this principle in taxation cases, uh, because whatever research that I could have done, it has not been used in varied substance with respect to taxation statute. Because if you see, taxation statutes are uh, basically quasi judicial administration functional based statute. So there is a line of authority flowing, there is a proper process of law of appeal and other legal remedy. So the legal remedy is ensured by a due process of law. Now in that due process of law, an authority would always be coming up with an adjudication as well as having the investigation power. So probably on that ground, this principle might not be applicable, but we have to see how the court in TVL case apply or takes notice of this principle. In one case, we have challenged this principle, and the case relates to a show cause notice issued by the commissioner on his own investigation. So the audit party had conducted the audit and had not indicated any default in the audit report. After a while, the commissioner, on his own investigation, studied that the case file before the audit, the case file of the SSC, and ended up issuing the show cause notice on its own. He was the writing authority of that show cause notice, and at the same time, he himself made him as the adjudicator of the case. So we have also challenged this arbitrary exercise of the commissioner on this principle, and we are waiting as to how the proceedings in this case takes place. I'll take this principle and then we'll have comments from Naveen sir. Expressio unius es exclusio alterius. It says the expression or inclusion of one thing implies the exclusion of the other or of the other alternative. Now, this principle says that when you have a law has prescribed a certain provision, express provision with respect to a subject. So when I say that with respect to class A of persons, ITC shall not be available. Now, in itself, it indicates that with respect to class B of persons, the ITC would be applicable. It cannot be say that since ITC provisions are subject to this and that provisions, and class B does not have a prescribed very specific provision for availing the ITC, the very restriction with respect to class A is indicative of the fact that class B is eligible to take the ITC. Having said that, this principle is subject to very cautious exercise, and over the years, the application of this principle has been reducing and reducing. And in the recent judgments, this principle is very negligible to be find in. Uh, in Rickett and Coleman of India Limited, the tribunal observed that maximum is merely an auxiliary rule of statutory construction to be applied with great caution. It is not of universal application and it is not conclusive as to the meaning of the statute. So it says that it is only a corroborative principle. You have come to a conclusion with respect to some other interpretation of the law, and this principle is only substantiating or corroborating that conclusion, then only this expressio unius exclusio alterius principle can be applied with. I'll skip this GVK part, and if you see the possible application of this principle in GST, we have serial number 15 of RCM notification amended by 2019 notification. It says any person other than a body corporate who supplies services to a body corporate and does not issue an invoice charging central tax at the rate of 6% is a defined category under the reverse charge. Ensuing circular 130 says that there are only two rates applicable to the service of renting of vehicles, which is 5% and 12%. So it says there are two cases. It identifies only two cases of 5%, 12%. And the interpretation therefore is that if the person is not issuing the invoice with respect to 12% GST charge on his invoice, then only this RCM notification would be applicable. That is, the interpretation is that uh, since it is identifying only two rates which is 5% and 12%. Now, this 5% and 12% are only identifiable in the heading 9973, or I would say 9966, where it is, uh, uh, sorry, the two rates of 5% and 12% are provided only with respect to heading 9966, which is rental of services or transport vehicle with operators. So it automatically means that 9973, which does not cover these rate of entries, is not covered by the serial number 15. So we could apply this expressionis exclusio alterius to say that when tax rate are defined in terms of 5% and 12%. Therefore, all other tax rate are not included within its coverage. And since 9973 only provide 18% rate of tax, it is not covered by the entry which only provide for 5%, 12% rate of GST. So it could be said that wherever this entry 1973, which is leasing or rental without operator, is in question, when a cab is hired without operator, then uh, the RCM entry under sale 15 should not be applicable. Naveen sir, on these two principles, if you have anything.
Yeah, sure, Manish. On casus omissus, I was able to find one judgment of the Supreme Court,
Okay, sir.
AR 2003, Supreme Court 2917, in Union of India versus Rajiv Kumar. I will just read the uh, gist of it because we don't have time to discuss the entire judgment. There they say that under the first principle, a casus omissus cannot be supplied by the court except in the case of clear necessity and when reason for it is found in the four corners of the statute itself. A casus omissus should not be readily inferred, and for that purpose, all the parts of a statute or section must be construed together, and every clause of a section should be construed with reference to the context and other clauses thereof, so that the construction to put on a particular provision makes a consistent enactment of the whole statute. This would be more so if literal construction of particular clause leads to manifestly absurd or anonymous results which could not have been intended by the legislature. A casus omissus ought not to be created by interpretation, save in some case of strong necessity. There is one more judgment which can also be referred. AR 2003 Supreme Court 2434 in Shiv Shakti Cooperative Housing Society versus Swaraj Developers. There also a similar observation was made by the court. This is on casus omissus. When it comes to
Right.
the namo judex in casa sua, in fact, that principle is a part of natural justice, and it is a principle evolved by the courts, although it is not strictly followed in tax matters. Person who issues the show cause notice decides the case. In fact, that is the one main reason why there is high litigation in tax matters, because the person who issued the notice is already biased and he is not in a position to give up to consider the pleadings made by the other side. So this is not a good trend in tax matter, but nevertheless, since the special law overrides the general law, you cannot apply the maxim in a case where statute specifically provides for it. And coming to expressio unius exclusio alterius, I saw one judgment of the Supreme Court, a very profound observation. Incidentally, an excise case in Commissioner of Central Excise versus National Tobacco Company of India, AR 1972, Supreme Court 2563. Supreme Court said that this maxim is often a valuable servant but a dangerous master. They also said the rule is subservient to the basic principle that courts must endeavor to ascertain the legislative intent and purpose, and then adopt a rule of construction which effectuates rather than one that may defeat the purpose. So, over to you, Manish. These are some observations.
Yeah, right. So we have some another principle of unless the context requires. So many times, or I would say in majority of the times, the definition part of a statute, section 2 or 3 is usually craved out by. It says the definition begins with the wordings unless the context requires otherwise. So whenever we see the definition that is being provided in a statute, we have to see the context of it. And unless the context is such that the definition that is used by statute would enable, that would render the application in the statute at some point of time, would make it absurd, then obviously a court could depart from the definition provided in the statute and interpret it in generic sense. Now, this provision was a case of material dispute in the case of Printer Mysore Limited versus ACTO, wherein the newspaper publishers were trying to say that their ink that they have been producing, that the ink that they require for manufacturing of newspaper should be allowed to them under the concessional CST rate of 2% or 4% as it was earlier. It said the argument of the revenue was that the goods part, which is manufactured by the newspaper publisher, excludes newspapers. So when it says goods required for goods, the second time goods should be only taxable goods that are covered within the ambit of CST Act. So if we read this interpretation in based on the definition provided in the CST Act, those newspaper publisher would not have been able to procure the inks and papers under the concessional sales tax entry. So the court interpreted that this unless context requires is very much applicable to this case, because if the newspaper publishers, again we have the sense of freedom of press in came into this light. So it says unless the context requires is interpreted, the goods would end up being only taxable goods, which is not envisaged by the state legislature or the or the statute that is making that legislation. So therefore, the court interpreted the goods appearing second time in the definition of of Section 8 of the CST Act as goods in a generic sense, and that included the newspaper, and therefore the court ended up granting the benefit of CST at concessional rate to newspaper publisher. This was again this similar interpretation was again the point of contention in the case of Kaparo Power Limited, wherein the Punjab and Haryana High Court had allowed the concessional rate of CST on the petroleum goods to those manufacturers also who were not manufacturing output goods in the nature of petroleum goods. So if we see that this context, unless requires interpretation, could be borrowed into any other provision of the GST Act also, one possible and very highly likely provision which can be used is Section 73 and 74 of the CGST Act, which calls for recovery of input tax credit. Now, if we read input tax credit under Section 62 and 63 of the CGST Act, it says credit of input taxes of central tax, state tax, integrated tax, and union territory tax act. It does not include the transitional credit within its ambit. So can it be argued that Section 73 and Section 74, with respect to after reading 262 and 263, exclude transitional credit out of its ambit? Probably it should not be, because when we see Section 73 and 74, we should be interpreting that input tax credit in its generic sense as to what all could be input tax credit within the purview of GST Act. It includes input tax credit as has been specifically stated so under GST Act 3B, and it should also be include those credit which has converted into credits of CGST, the GST legislation, and therefore it should be also included within its ambit those transitional credits. More particulars no, because the provisions of the previous regime have been repealed by Section 174, and the savings provision has specified that the credits that were earlier availed and have become recoverable would be recoverable under the provisions of this statute. So we have to read this Section 73 in harmony with Section 174 also, and therefore with that the meaning of what input tax credit should include the transitional credit also. In a highly unlikely case under GST, where this principle might have been argued, is the definition of export of goods. Now, this definition of export of goods under Section 255 of IGST Act is barely imported from the Customs Act, when it says the export within its grammatical variations and impressions include export taking goods out of India. Now, in a VAT statute, there are cases where the goods do not explicitly leave a particular area. However, their consumption is definitely or their constructive consumption is definitely happening outside of that area. So in a VAT statute, you always have a room for interpreting the consumption, and therefore the export of goods should be with respect to, I would say, a case where the tools and dies which are although in India, but their consumption by their constructive consumption by the with the use of the tools and dies in respect of manufacturing of goods and components is happening outside India. So probably those cases, export of goods should be interpreted in a VAT principle manner. We have the theory of immediate use. I'll come back to Naveen sir once I read all these residuary aspect, and then probably we could take manifest arbitrariness argument. So this theory of immediate use is a theory and not necessarily a doctrine. It says that when a provision is has a broad concept and then it has some exclusions to it. So as per this use, the exclusion should be read with respect to their immediate use, and narrower interpretation should be given to them. So in Tata Engineering and Locomotive case, where the dispute was respect to a captive consumption central excise entry to 1786, wherein the exemption to captively manufactured goods was allowed on inputs. Now, inputs, it said, does not include machines, machinery, plant, equipment, apparatus, tools, or appliances used for producing or processing of any goods. Now, in this particular case, the assessee telco was manufacturing forklifts, cranes, uh, and other similar items like uh, so other similar items like trolleys, conveyors, etc. Now these equipments were not directly used for manufacturing those goods, but these are allied instruments through these products were to be carried out in the whole factory. Now the Supreme Court held that when you are interpreting the words used for producing or processing of any goods, it is indicative of only direct or immediate use. That is, only those machines that are used directly for manufacturing those goods should be interpreted in this exclusion. Now, keep in mind this exclusion is not the generic rule, because in a generic sense, a manufacturing process is tend to include all the activities that are relevant for manufacturing, and that would include the use of forklift and conveyors, etc. But this is an interpretation of an exclusion to our broader spectrum of things. So therefore, this immediate use theory says that you should be interpreted exclusion to a broader concept in a narrower way. Similarly, we could use this theory by interpreting the words for construction in section 17(5)(d) of the CGST Act. So it says goods and services used for construction of immovable property are not entitled for the input tax credit. Now, how should I interpret this word for construction? Does it include all those directly usable goods, or it should also include indirectly usable goods? The surveyors, the services of a surveyor who I hire for a potential land searching, is it coverable within the immediate use theory or not? Is it can we call it as directly usable for construction? Probably not, because these services have a nexus with the immovable property, but these I'm not utilizing these services for the construction activity it's effective. The construction activity it means that I'm building a superstructure. Now the surveyor services are not at all relevant for building that superstructure. Superstructure only requires me to hire a subcontractor. It requires me to buy bricks, sand, cement, etc. Not that it requires me a surveyor services to build that superstructure. So probably we could say that section 1615, section 17(5)(d) for construction should be used in a narrower sense, and only services or goods and services that are directly usable for construction activity should only be included within its ambit. The next principle is mandatory versus directory. Mandatory rule requires strict observation, while directory rule requires substantial compliance. Uh, So with strict observation, it means that there is no qualification available. A man has to definitely comply with the mandatory rule. While with respect to directory rule, he can apply substantially. So there is, when I say there is a limitation to comply with the certain provisions, although he may comply with it belatedly, but since he has complied, he has substantially complied with that rule. So therefore, mandatory versus directory rule often comes into question before the courts. In Sharifuddin versus Abdul Ghani loan, Certain broad line principles proposition has been highlighted by the Supreme Court as to judge whether a principle is directory or mandatory. The 7-8 principle are that the fact that statute use the word shall is an indicative of a duty, and therefore it should be more question, it is indicative of a directory provision, mandatory provision. Then it says, in order to find out the character of the legislation, the court has to ascertain the object. So if the object is that this has to be complied very strictly, then obviously there has to be construed as a direct mandatory provision. Then it says the object of a law is defeated by non-compliance with it. It has to be regarded as a mandatory also. Similarly, there are other provisions also which helps in deciding whether a provision is mandatory or directory or not. Now, in brand equity case, the Delhi High Court observed that time limit under Rule 1171 is directory, in as much as no consequence has been attributed to its non-compliance. Probably this, and it has obviously relied on some criminal cases. Probably this discretion, this reasoning provided by the Delhi High Court that it is directory merely because it doesn't have any consequences, it does not hold water. But if we read the directory and mandatory principle in its first principle, then it could be said that the rule 117, the time limit under rule 117 of the GST rules is directly in nature. So probably reliance on this judgment may be of some use, but not entirely out of the context. Uh, Similarly, when we say that the section 140 has provided a time limit under time limit power under uh, time limit power to the central government to prescribe for a time limit to avail transitional credit, it still has not made the time limit as a directory or mandatory, because if you see 117 provides that the time limit to avail transitional credit. Now any person could argue that the time limit that has been provided by 117 is a directory provision, so there is no intercourse of 140. There is no debarring from 140 that time limit is directory or mandatory. So, although this decision has been to an extent reversed by the notification of amended section 141, 140 subsection 1, however, at all the SSC should not be discouraged by this amendment. Then we have another principle of this mandatory and directory. This is a negative language in a law usually indicate that this provision is a mandatory provision, while a positive language indicates that it is a directory provision. So if you see section 39 says shall furnish, while subsection section 18.2 shall not furnish. So shall not furnish says the time the application would have to be furnished within the period prescribed. So and section 39 says shall furnish. So there is some leeway available with the SSC to file even beyond the time limit provided under this act. If we see notification 329, which is relevant for the real estate sector, wherein new scheme was implemented for real estate, and those persons opting for old scheme were required to intimate in annexure 4 within within the before 20th May of 2019 as to their intention. So probably this time limit of filing annexure 4 should be interpreted as directly, because again it is a positive language. The other two principles are lex non cogit ad impossibilia, which says that any impossibility of performance is a void. If a man cannot do a thing which is absolutely impossible by its nature, such contract will not be bind upon him. Now, again, section 16(2)(c), which provides that ITC availability with respect to payment of a tax. Now, how can a person within the available limits, within available resources, could verify whether the tax has been paid or not? So section 16(2)(c) could be is susceptible to the challenge of this principle of impossibility of performance. We have another last principle of rule of last antecedent, which is an interpretive principle by which a court determines that qualifying words or phrases modifies the words of phrases immediately preceding them, not words phrases more remote unless the extension is necessary from the context or the spirit of the entire writing. So it says that when a sentence is using some qualifying words, So those qualifying words should be read only with respect to the last antecedent, that is the words previous antecedent to it. Now, if we see an example in Rule 9610, which says that two expressions are used. It says that the persons who have claimed the exemption, who have availed the benefits under this is its notifications. These notifications are EOU and this advance authorization and EPCT. So whether this the restriction in 9610, which is shall not be entitled to export under on payment of IGST, is qualifying the very persons for it, or it is only qualifying those transaction where the benefit under this notification has been availed of. Probably if we apply this principle, we could say that the person itself does not become ipso facto, does not become ineligible to claim refund under section 90, under rule 96. It is only those transactions which are covered, which have been made without by using the notifications given therein, are only disqualified. So with this, we can conclude on these provisions. I would like to have comment from Naveen sir. And if we have some time available, I'll briefly discuss the principle of manifest manifest arbitrariness. Over to Naveen sir.
Thank you, Manish. Uh, a couple of points on mandatory versus directory. Whenever the provision is mandatory, there is no scope for relaxation. We have examples like time limit for taking credit, time limit for filing refund claim, or time limit for demand or recovery by the department. And even you look at Rule 5, refund of credit under the past regime, Section 11B was made applicable, and that has been construed as a mandatory condition. There is no scope for relaxation. At the same time, whenever there is substantive compliance, when in the context of beneficial schemes or notifications or exemption, the courts have laid down the proposition that there is a possibility of taking a lenient view when it comes to compliance of procedures when substantive condition has been fulfilled. In Auria Chamber of Commerce, the Supreme Court said that the procedures are only handmaid of justice and not the mistress of law. And similarly, in Suksha International case, the Supreme Court said the benefit which is granted with one hand by the policy of the government cannot be snatched away with the other by a narrow interpretation. So this is how the courts look at it. But it is also important to identify whether a particular condition is mandatory or it is only a directory in nature. And coming to the next aspect, uh, there are some words which are used in the statute, like what Manish was pointing out. Sometimes it would say shall, sometimes the word may would appear. The courts have also taken a view based on the context. Sometimes they construe shall as may and may as shall also. So it depends on the type of issue and the nature of the case and what is the requirement in a particular context. Then finally on this lex non cogit ad impossibilia, we all know that this Tran 1 form could not be filed because of technical glitches. Then that is one example where we used to frequently apply this principle while drafting the writ petitions. And the courts have also been lenient in saying that you cannot compel someone to do the impossible. Yes, Manish.
Yes, sir. Thank you. Thank you for your comments, sir. Rashmi, if we have some question, we can probably take it up and try to answer it within 10-15 minutes, because we may want to have some discussion on manifest arbitrariness. Otherwise, this
We have not
doctrine
received
will
any
could have.
questions. Uh, Participants can post, but we have received one question through mail. I'll read out that.
Yeah.
The question is whether the ITC can be availed on full GST charge on undiscounted supply. where after the post-purchase, the supplier has issued commercial credit note. Say telling as per Section 262 of CGST Act, where the words are used as charged and not chargeable. So can we avail the full credit when the credit note, commercial credit note is issued?
All right. I think this question is not related to the present discussion, but anyway, I think it is very well possible to say that the discount through a commercial credit note has not reduced the tax on a particular transaction. So therefore, when a tax has been deposited, why I am supposed to reduce ITC on my purchases? It is very fairly relevant to say that ITC with respect to a particular invoice which has been subsequently discounted by a commercial invoice, then ITC should be available if the corresponding supplier has not reduced his GST on that invoice. I think there was discussion between in the Advanced Ruling Authority also in the case of MRF, which was subsequently overruled by the circular issued by the CBIC. But again, this circular itself was overruled on account of his other fallacy. I'm not seeing that this overruling of circular has revived that advanced ruling authority decision. We have decisions under the erstwhile regime also, wherein the court have been categorically held that this discount through commercial credit note should not disentitle the Sinvet credit by recipient. I'm not able to recall any judgment on this as of now, but yes, there are judgments, and probably we will reach out to them in the due course of the time. But in the meanwhile, if Naveen sir has something to say on this.
No, you can proceed with that manifest arbiter.
Okay, thank you, sir. I think I'm seeing some questions here, sir. Is it, Rashmi, is it related to previous discussion?
Now we have received one question. In case of
Okay.
TRAN, Delhi High Court said limitation period is 3 years. We have to complete TRAN 1 before 30th June, or we can go beyond June.
So if we see that brand equity judgment, it was the court went on the premise that there was no time limit prescribed. So since there was no time limit prescribed, could you file the Tran one forever? Therefore, the court imported the provisions from the Limitation Act and provided 3 years time limit. Now that you have a retrospective amendment and the law has itself provided for a time limit, the question now shifts from 30th June, the 3 years time limit, to the time limit provided under Rules 117. Now we have Rule 117 versus the 30th June that has been prescribed by the court. We have to see whether this and it appears to be, since the Limitation Act has a specific provision that it is only applicable when the limitation is not provided by the statute itself. Now, since we have the time limit available in the statute, definite time limit power available in the statute, you should not be taking recourse to the Limitation Act. But again, you still have the comfort of seeing Rule 117 as a directory or mandatory. You should be seeing that 117 as a directory provision, and you should always have a case that 30th June or for that matter any other time limit is not a relevant condition for filing Tran 1. Having said so, what you can do is you can file your Tran 1 within the 30th June 2019 to say that in further proceedings that all you were doing was complying with the order of the Delhi High Court, a statutory, a legislative, the protector of the law, the sentinel of the law. So therefore, you would in the subsequent I might not be saying that this in subsequent proceedings, a higher court, a superior court would succumb to the this 3 year time limitation, but at least you would be able to justify as to on what basis you had considered this 3 year time limit. So I would recommend to file the Tranmin within this 3 year time limit period, but that is again depending upon as to how Rule 117 is read by the superior courts. Thank you. Naveen sir, if you have some any comments on this.
Yeah. See, as far as the limitation is concerned, earlier there was no limitation, only the rule prescribed. Now that there is a retrospective amendment, the government, question is whether the legislature can amend retrospectively. Answer is yes. But the only thing is, whatever is defect is pointed out by the court should be cured. Have they cured it? Yes. There was no limitation in the act. Now they have provided for. Therefore, the government would challenge that judgment before the Supreme Court, and they would take a view that we have overcome the defect pointed out, and therefore that the general law of limitation would not apply. So, and of course, this battle will take some more time. In the meantime, it is. I would recommend whatever Manish suggested, that you take a chance, take a credit, and later on, if the Supreme Court decides against, you can always reverse it. Alternatively, to avoid interest, etc., you can take credit, reverse it under protest, so that the for taking recredit there is no time limit. After Supreme Court says that there was no time limit, therefore 3-year limit would apply. So it depends on the stakes involved also. Yes, Manish.
Yeah, thank you, sir. I'll discuss about the very, which is has gained my you know attention in recent past, the doctrine of manifest arbitrariness. So it is acceptable principle that a, a statute under the constitutional wise is only challengeable on two grounds: one, that it is beyond the legislative competence, and other, it is dehoards the privileges under part 3 of the constitution, which are fundamental rights. Now, we have seen a concept of manifestly arbitrary. Article 14 is a discrimination doctrine. It is a classification doctrine. It says that you can classify, you can create a distinction between the two persons, but it should be reasonable, and the classification should have a reasonable object with reasonable nexus with the object of the act. So in this paradigm of article 2, article 14, where we have the classification test, where comes the word arbitrariness? Now, if we ignore for the moment what is manifest arbitrariness is, there is an inherent arbitrariness in article 14 itself. It means that article 14 prohibits discrimination. So therefore any exercise of arbitrarily arbitrarily making a provision which is not reasonable, not is which is unreasonable, in the sense that you are classifying two persons. Once you have a reasonable classification, you can do so. But however, when you are doing it unreasonably, when you don't have any object at all, then it is discriminatory, it is arbitrary. So arbitrary in the nature of discrimination, it is stemming from the article 14 itself. Now how come now where comes this manifest arbitrariness? In the case of EP Royappa, this arbitrary manifest arbitrary doctrine was given to a rise by the Supreme Court. It says that equity is antithetic to arbitrariness. When an act is arbitrary, it is implicit in the act that it is unequal both according to the political logic and constitutional law, and therefore violative of Article 14. So this court traced this arbitrariness to the antithesis to equity. So therefore, if equity ensures equality, inequality is prohibited, and inequality is comparable with the arbitrariness. So if any provision is arbitrary, not that it is discriminatory, but it is arbitrary, it is always susceptible to wise. It is always available for challenge to a legislation. Now, this judgment was followed by in various judgment after that. Most notably in Ajay Hasia case, Justice Bhagwati was there. This was a 5-member bench, and continued to hold good in various other cases until in another McDowell case. Now, this McDowell case is different from the one we had studied in the tax planning case. It is a 1996 judgment wherein the court stamped upon the fact that a statute can be susceptible to constitutional challenge only on account of two provisions, which is lack of legislative competence, and again the part 3 or any other constitutional rider. It ignored that manifest arbitrariness doctrine. Now, this doctrine has again been revived by Justice Rohinton Nariman in Shaira Bino case, and the Chief Justice had extended the arm of manifest arbitrariness in a sense that it has excluded arbitrariness from Article 14 and explored the different contours of arbitrariness. It says that Article 14, which covers arbitrariness in the nature of not reasonable, this manifest arbitrariness cover arbitrariness in the reason of not being reasonable at all. So therefore, you have class legislation. It is reasonable, then it is available. If you have unreasonable, it is not available. But now you have this manifest arbitrariness, which says that class-wise legislation is reasonable also, but it is excessive, it is harsh, it is disproportionate. So then also it is arbitrary. Now this doctrine has been accepted and given with respect to a legislation. However, the flaw with this, with the argument or with the commentary of Chief Justice Rohinton is that it uses certain precedents such as E.P. Royappa, Ajay Hasia, with an inherent flaw. Like if you see Ajay Hasia in this case, the legislature was not struck down with respect to arbitrariness, manifest arbitrariness. It was an executive order which was struck down on account of manifest arbitrariness, and it also has laid down to some other judgments wherein the legislative act was struck down on account of manifestly arbitrariness. But if you see those judgments that have been relied upon by Rohinton Nariman are the cases where the legislative act were already held discriminatory under 14 or Article 19 or some other provisions of the law, and manifest arbitrariness doctrine was only used as a corroborative argument. So therefore, the application of this the re-emergence of this manifest arbitrariness doctrine in Shaira Bano case has expanded the constitutional challenge. Now, this has created disharmonious provisions. Whether the court should be applying this provision in other cases also or not, because of this inherent flaws in other statutes, more precisely the tax statute, it becomes an difficult proposition, because on the one hand you have an inherent limitation of taxation statute that they are read in conjunctiveness of constitutionality. Now you have another doctrine which is manifest arbitrariness, one which is itself having its flaw, and then you have the restriction of taxation statutes. Now, applying this manifest arbitrariness in taxation statutes is a bit difficult. Now, I'll come to why, if at all manifest arbitrariness is declared a good law, how this taxation statute could have a wide scale ramification. Now, suppose we have been taking an argument that a taxation does not recognize harshness. Harshness is basically an inherent arm of arbitrariness. So long as you are able to prove or extend your harshness in paying a tax liability, you will be able to prove manifest arbitrariness. And therefore, the court would be liable to reject this taxation statute on the garb of falling wise to the manifest arbitrariness. Now, if this proposition is accepted, it would have large scale ramifications, because over the years, it has never been held by any court that harshness in a provision or inability of a person to pay taxes is a ground to constitutionality of it. But this particular doctrine could be a variation to that stand taken by the courts. Now, in two cases that I was able to come across in Gujarat High Court in Reliance Industries case, this doctrine was applied by the Gujarat High Court to say that the amendment in Gujarat VAT Amendment Act is manifestly arbitrary. So much so that it creates it time and again it increases the limitation of reassessment. So long as you keep on increasing the reassessment, the issue would never come to bed. So the state would always have the power to legislate, and the issue would never reach to certainty. So in this ground, it held that it is manifestly arbitrary. So far, so good. But whether the inherent the inherent flaws that are there with the Shaira Bano case, that were not accepted or perused by Gujarat High Court. So therefore, although this decision, Reliance Industries, is valid on some other grounds, but manifest arbitrariness ground, it somewhat doesn't appear to be should not be taken as granted for. Similarly, in Philco Trade Center Private Limited, the Gujarat High Court again struck down clause 4 of the section 143, which restrict input tax credit on stock, which says that only 1 year previous 1 year input stock would be available for transitioning into GST. It says that you are restricting 1 year, you are providing a time limit of 1 year, which is manifestly arbitrary. How can you say that 1 year is a manifest is a rational, is a proportionate time period? You have not come across any evidence to say that it is reasonable. So what the risk I'm seeing is that the court has already embedded an argument of harshness in this in the taxation statute, and applied the principle of manifest arbitrariness, and of course relied upon the Shaira Bano case. So this could be a remarkable case in one aspect, and also it could be a very discouraging argument, because somewhere down the line the court might again revisit the Shaira Bano case and held that this manifest arbitrariness is not a good law. So therefore, taxation statutes has to follow the line of arguments, the line of decision that might be followed by Shaira Bano case. So that was the broad understanding, broad comment that I want to lay on it. Now, there is some other aspect that I want to highlight is that arbitrariness of an executive action is different from arbitrariness of legislature. Now, a legislature is arbitrariness of a legislature can be definitely challenged under Article 14 for it being discriminatory. But an executive action, the challenge of it arbitrariness flows from varied angles. The manifest arbitrariness angle of an executive action is definitely applicable, because an executive cannot exercise his authority in an unrealistic way, in a disproportionate way. This principle honors the Wednesbury principle, which says that every executive action should be reasonable. It appears to be fine with respect to application of manifest arbitrariness with respect to executive action. That is fine. But again, we have a challenge as to how this application of this principle should be applicable with respect to legislature. Uh, in some judgments that followed Shaira Banu, it was held by court that this manifest arbitrariness doctrine is an extended arm of Article 14. So therefore, there is an again a dichotomy as to how I will implement this principle of, or I would plead before a court the argument of an manifest arbitrariness, because in Article 14 at the end of the day you have to justify to the court that there is an equity involved. Now whether manifest arbitrariness is it being under Article 14 and regards to the test of Article 14 so as to identify, so I would have to identify equity in all cases, or if it is out of the Article 14, I may propose to the court that there is harshness in the provision, and therefore at the same time to a certain extent not go with the equality principle. Section 75(11) of the CGST Act, which is parameterial to Section 84 of GVAT Act, again it increases, it excludes the time taken before the judicial review from the limitation period of reassessment or the period for issuing the show cause notice. So is challengeable on the ground of manifest arbitrary. Similarly, there is one section 129 e-way bill penalty, which again does not distinguish between the mens rea and bona fide cases. So probably, if I read manifest arbitrariness in its proportionate variation, probably this doctrine could also be applied in respect of one section 129. So these are my brief comments. I would like Naveen sir to have any comment on this.
Thank you, Manish. Just a couple of comments on that. You are referring to Article 14 of the Constitution, which was also discussed by us elaborately last week. In fact, whenever there are exemption entries or is some classification, this issue may crop up. So someone may say
Right,
that there is no reason or rhyme for excluding certain persons from the purview of exemption.
right,
You
right,
take the Sabka Vishwas scheme. Some people were left out. Some dates, cutoff date was mentioned. If the inquiry was already pending but no show cause was issued before the cutoff date, then they said you are not eligible. So these type of things have been there. And suppose inquiry is already completed, notice issued, then the percentage is different. If it is voluntary, then some other percentage. So the test is whether
right,
these
right,
type of restrictions would bring it within the purview of Article 14. I would recommend that the participant should read the judgment of the Supreme Court in R.K. Garg's case. It is known as Special
right,
Bearer
sir.
Bonds case, which
Right, right, right,
explains this aspect. And I would also draw your attention to a decision of the Bombay High Court in Retailer Association case, where the
Mhm.
constitutional validity of renting of immovable property was challenged, and the court looked at whether there was any manifest arbitrariness before upholding the constitutional validity. It is reported in 23 STR 561. Of course, the matter has now gone to Supreme Court and is pending. These are some of the observations. If we have some more questions, we can take it.
Right, right. In fact, one rejoinder here is that if you see the R.K. Garg case, which is written by Justice Bhagwati, P.N. Bhagwati, Justice P.N. Bhagwati was the writer of Ajay Hasia case. So in R.K. Garg case, wherein Justice Bhagwati relied upon the special bail courts case, where the Justice Chandrachud or someone else was there, who had highlighted where it has been specifically stated that only two grounds are available, and manifest arbitrariness was not available. So in one case, this R.K. Garg case, Justice Bhagwati did not use the manifest arbitrariness, and in one case, Ajay Hasia, he had used the manifest arbitrariness. So there was an inherent dichotomy in his own judgment. So probably this has to see the light of some larger bench before coming to final scrutiny, sir. I think, yeah. So if we have
Rashmi, do you
question,
want
Rashmi, Rashmi, you have some questions, or we can conclude. Uh, I'm not able to see some questions there, sir. So probably we could conclude. So I thank
Okay.
all the
Hello.
participants for attending. Yes,
Yeah,
yes,
please.
Rashmi.
I hope all the questions are addressed. If any questions are there, you can raise or you can mail it to Divya also. Thanks to Manish and Naveen sir for explaining in a detailed manner, and that too on a weekend. On behalf of Hiraganga Academy, I would like to thank both for taking part. Thank you, sir. Thank you, Manish. Thank you, Naveen sir.
Thank
Thank
you,
you
thank
so
you,
much. Thank you.
thank you to all participants. Thank you so much.
And I would
One
like
quick,
to thank all the.
Madam, one thing before we conclude. In fact,
Yes, sir.
this topic is not a part of GST law, but you will find that this is a very useful topic to understand the GST law and any other tax legislation. I would recommend that the participants who are interested in further reading should refer to books like Broom's Legal Maxims or Trainer's Legal Maxims. There's a book called Latin for Lawyers, and there are law lexicons which contain a lot of information about doctrines I have also seen some books on foreign doctrines. I have also seen books on doctrines, legal maxims, Supreme Court on doctrines and maxims, which the participants may find it useful as a useful reference material when they do further study, because there are innumerable concepts and doctrines available. In a session of 3 or 4 hours, it is very difficult to cover all of them. But nevertheless, we have probably created some interest in the subject, and people who are interested would go further, uh, deeper into the subject and read it. Thank you.
Right. Thank you.
Thank,
Thank you, sir. Thank you
thank
so
you for
much.
the suggestion. Hope our participants will make use of it and will go in and make read and make best out of. Thanks to the participants who attended and made this session a success. Thanks to all.
Thank you. Bye.
We'll be
Bye.
up
Thank you.
session. Thank you. Thank you.